Plaintiffs versus Charles T. Schrackle and the Schrackle Construction Company for the defendants. Are the defendants ready to proceed on pretrial matters?
We are, Your Honor.
Great, and would you introduce yourself, please, for the defendants?
My name is Brian Johnson, along with Christina Zuniga and Amanda Jensen.
Great, okay. All right, so ladies and gentlemen, if you have any housekeeping matters, would you go ahead and bring them forward, please? Does the plaintiff have any?
Yes, Your Honor. We prepared a PowerPoint to illustrate the photos that are in the exhibit list to better explain and show the jury how the intersection that is in dispute right now takes place, or how it operates.
Are you saying that the PowerPoints explain better than the photographs?
Yes, ma'am. They're in photo, in color on the PowerPoint versus their black and white in the exhibit, the trial number.
And what does the defense say to that?
Your Honor, we have no objections to the PowerPoint as long as we have access to the same exact PowerPoint.
Have you not been provided the PowerPoint?
No, Your Honor, we have not. We have not, Your Honor.
And you don't have any objection?
If it's not in this trial notebook, it's not going to happen. So the PowerPoint, we don't want it.
Okay, well, in that case,
Your Honor,
Miss.
Your Honor, the PowerPoint was prepared through one of our teammates. They prepared all semester on it, and it's just an upload. The textbook with the problem comes with a CD at the end of the book that provides the actual photo, color photo, in the back of the textbook.
All right, well, okay, so from what I'm hearing right now, there's no objection at this time from the defense. So when that matter, if that matter comes up during the course of trial, Ms. Scott, is that right? So if you will just identify the exhibit, and if the defendant wants to object at that time, then they can, and we'll take it up then. All right, do you have any other matters?
Your Honor, will we have access to the same PowerPoint, the defense, to the same exhibits?
Well, I don't know because I haven't seen it yet. So if you don't have any objection at this moment, then when it comes up, if it's identified properly, what do you know what exhibit it's going to be? Is it numbered yet?
Yes, ma'am. It's exhibit 10, 11, 12.
10, 11, and 12, and are those three separate PowerPoints?
There's three separate PowerPoints that illustrate the photo and the diagram of the intersection of the photo.
Okay. And the way I have them marked is for identification, Exhibit 10 is the photo across to White Castle. Is that
Yes, ma'am.
okay? And number 11 is photo where Schrackle turned from.
Yes, Your Honor.
And 12 is photo down crosswalk toward Marshall's.
Yes, Your Honor.
All right. So, right. So I'm asking you not to display the PowerPoints in front of the jury until I have an opportunity to rule.
Yes.
Okay. You wouldn't display it until it was actually admitted into evidence, in other words.
Yes, ma'am.
Okay, great.
And I also have a couple of other 16 and 18, which are there's still photographs of the diagram of the intersection, and I can't remember the description of the.
Okay, I showed 16 as the photo of the median next to Schrackle Turn Lane,
Yes, ma'am.
and 18 is photo of Victoria's Vantage.
Yes, Your Honor.
And are you saying that those are PowerPoints also?
Yes.
Is there any objection at this time from defense, or are we going to follow the same procedure as we're following on exhibits 10, 11, and 12?
We'll follow.
Okay.
Follow the same procedure.
All right. Is there anything else? Okay. Anything, and no other housekeeping matters from the plaintiff?
No.
Okay. Anything from defense?
No, Your Honor.
Have you agreed on the admission of any exhibits?
Yes, we've agreed to exhibits 2, all the way through 2 through D.
Okay, all right. So I show 2, the diagram of the intersection. Are we all in the same place?
Yes.
Okay. 2A, 2B, 2C, 2D is in David. Number 3, exhibit number 3. And the next exhibit I show agreed is exhibit 5,
Correct.
7, 8. And then the actual photograph, not the PowerPoint, but the photograph I see agreed as to 10, 11, and 12. Is that correct?
Yes, Your Honor.
All right. Exhibit 13 is agreed. Exhibit 16 is agreed as to the photograph, but not as to the PowerPoint. Is that correct?
Yes, Your Honor.
Exhibit 17 is agreed. Exhibit 18 is agreed as to the photograph, but not the PowerPoint. Is that correct?
Yes, Your Honor.
Exhibit 19 and 20 are agreed. 25 is agreed.
Your Honor, 21 was also agreed upon.
Is that correct?
Yes, Your Honor.
Okay. I have 21 is agreed. 29, 30, 31 are agreed. And what is the status on Exhibit 32, which is the photo of Potter and Tobias and Martinique?
We want the defense to lay the foundation.
We agreed to the exhibit.
Okay, so it is not agreed.
Correct.
All right. 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, and 47 are all agreed, and 48 is agreed.
Sure.
That's correct? Okay, are there any other housekeeping matters from the defense?
No, Your Honor.
Are both sides ready for the jury to come in and proceed with the trial?
Your Honor, just to clarify, for the photographs that are in the PowerPoint, do we need to lay the foundation for those?
If you want to admit the PowerPoints, yes, you will need to lay the foundation for those because they are not agreed, and I'll hear any objection outside the presence of the jury at that time. But at this time, the photographs themselves, I guess, I haven't seen the PowerPoints, I guess upon which the PowerPoints are based, just those photographs I show agreed. Is that correct?
Yes, ma'am.
All right. Okay. Any other matters? All right, are both sides ready for the jury? Is the plaintiff ready for the jury?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Okay, great. Bailiff? Bring the jury in, please, and everybody rise.
All rise. UHCL mock trial is now in session. The Honorable Judge Weber presiding.
Ready for the jury? Yes, sir. Bailiff? Okay, okay, I see. Do we have all our jury members here?
Yes, except jury number 9.
Okay, are we ready to move forward? Great. Members of the jury, you may be seated. Thank you for your time. Everybody else, you may be seated. All right, I call the case of Jeffrey T. Potter, the administrator of the estate, and of Catherine Potter, Jeffrey T. Potter individually, as plaintiffs versus Charles T. Schrackle and the Schrackle Construction Company, the defendants. The jury is seated. Are the plaintiffs ready to proceed?
Yes, Your Honor. Yes, Your Honor.
Is the defense ready to proceed?
Your Honor, we are.
Okay, the plaintiff may open.
May we proceed with the board item?
Oh, I'm sorry. Yes, absolutely.
Good afternoon, ladies and gentlemen. My name is Heather Scott, and I'm with the law firm for Hart Scott. Myself and my colleagues have the honor of representing Jeffrey Potter in this case. Now, this case is about taking responsibility for wrongful actions. The wrongful actions
from a distracted driver.
He wasn't even properly without a
This distracted driver, charged
and as a result of his distractedness, he caused a pedestrian
to lose her life.
as they were crossing the street. Now, this pedestrian could have been anyone. It could have been your child, it could have been your mother, it could have been somebody else. But today, he distracted parties not. So right here, the distracted party has incurred a reasonable amount of expenses from his wife's tragic death, and has yet
To emotionally involve.
been able to for him a sad day. Now, before we go any further,
I would like to talk to you about the verdict on this case. Unlike in a criminal case,
where you've heard the phrase beyond a reasonable doubt, our verdict in this case is preponderance of the evidence. And all that's
Opinion.
is that more likely than not,
Mr. Shrunken caused Mrs. Potter's death. Now, I'm going to tell you today that we are going to prove our case by 100% that Mr. Shackle caused Mrs. Potter's death. But all we have to have is 51% of the evidence in our favor in order to win our case. Now, is there anyone here who has the slightest hesitation in awarding a verdict against the defendant from what you heard so far? Does everyone here hold a driver's license? So everyone here knows of the rules and responsibilities drivers have while driving on the road. Am I right? So who feels here that it's very important to keep a proper lookout of the road ahead of you when you're driving? Who feels that it's very important? Why do you feel like that, jury number 12?
Feel like that's important because it sets boundaries for other drivers that you could be the pedestrian one day to get injured.
Okay, with that being said then, who here feels that drivers and pedestrians hold the equal responsibility while traveling on the road? Does anyone feel that they hold an equal, why do you feel like that, jury number 12?
Because it is a lot of factors that can counter into that, whether it's a driver accidentally loses sight during driving, or the pedestrian is not in all of his senses and can cause an accident, so it can go either way.
So if they're equal responsibility. So you feel like a pedestrian versus a person that's driving a vehicle on a steel box that weighs 2 tons, they hold the equal responsibility on the
Yes,
road.
because there could be a family in that automobile.
Okay. Well, thank you for that. So who feels that they do not hold an equal responsibility while traveling on the road? Does anyone feel? Why do you feel like that, jury number 11?
Well, in any of those kind of situations, I guess the driver really has to do is just stop. Pedestrian has to use not jaywalk at times.
So you feel that they don't have an equal responsibility? They do.
They don't.
Okay. So what if, we just talked about the rules and responsibilities of drivers. What if these rules and responsibilities were broken by any means and caused someone harm? Does anyone here feel that they would have a problem awarding a verdict and for money for the harm that they caused for the medical bills of that person? Does anyone feel that they would have a problem awarding money for medical bills? No problem. Okay. What about the pain that someone experiences from a accident or something that happens to them that hurts them? Does anyone feel that they would have problem awarding money for the pain and suffering through that pain for a purpose like that? Would anybody have problem with awarding any kind of money for like that? No? Okay. Now, there's another type of monetary awarding or, okay. God. Does anybody have trouble with awarding money to teach a lesson to prevent acts from further happening, from companies hiring drivers, irresponsible drivers? Does anyone have a problem awarding money to teach the community a lesson of making sure that their company hires responsible drivers that keep a proper lookout of the road ahead of them and follow the rules accordingly to the rules and regulations of drivers? Jury number 8.
At the very least, it has to be kept within reason. So if these people, I don't think one person should bear the burden of all society because they made a mistake.
Okay. Thank you. Now, ladies and gentlemen, there's another type of damage I'm going to talk to you about, which is mental anguish. And these type of damages, they cannot be counted, they cannot be measured, and there will be no expert witness here to testify on the amount of these damages. However, these damages are for you to decide based upon the testimony and evidence you hear today. Has anyone here ever lost a loved one before? Can you tell us a little bit about that, jury number 8?
Just family members pass.
And did they? I'm sorry to hear that. How did that make you feel? Did you feel any like mental anguish, pain from this, mentally and emotionally?
Time that comes to mind, I was a kid and I had to take off school.
And it set you back a lot, like with your life, didn't it? Out of and so can you tell us a little bit about how that happened? Who was it that you lost?
It was my father. He just passed away when I was pretty young. I was 10, but he just went in his sleep, so at least it wasn't traumatic in that sense. But
I'm very, very sorry to hear that. And sorry about that. Has anybody else here been through the same situation? Sorry to hear that. Is anyone here married or have a boyfriend or girlfriend or even a best friend that they're really close to? Can you tell us a little bit about that person?
Yeah, sure. My friend Alyssa, we've grown up together, known her about 15 years, so we're fairly close to each other and we care about each other.
So would you say that you rely on her emotional support and guidance from this person?
Right, she pushes me and propels me to do things that otherwise I'd be not inclined to do.
And if you lost that, you would feel very hurt from this loss, wouldn't you?
Right, it would set me back in my personal life.
And how about anyone else? If they lost the emotional support they received from somebody, how would that make y'all feel? Very lost, and you wouldn't know where to go. You wouldn't know who to call to if you have a problem in your life. So what you heard so far, would there be anyone here that would have problems with awarding money for something like mental anguish? How about you, jury number 11?
For mental anguish or clinically have a problem to that you would have to give pretty grievous.
Okay, respect that. Well, thank you, ladies and gentlemen. That completes our board hour.
Okay, ladies and gentlemen of the jury, I want to tell you at this time that we have reporters in the courtroom whose job it is to write down everything that is said and to protect the record and just in case there is ever a question about this trial. So they need to be able to hear you clearly. If you don't mind speaking up, then that would be very appreciated by them, I'm sure. And I've instructed them that if they have any trouble hearing, that they are to shout out and let us all know. So let's try not to let that happen. But anyway, their job is to protect the record. So I appreciate everybody's cooperation on that. Is the defense ready to voir dire?
Your Honor, I'm ready.
You may proceed.
Thank you. Ladies and gentlemen, hold on.
Can y'all hear me? There we go. All right. Ladies and gentlemen, my name is Christina Zuniga, along here with Brian Johnson and Amanda Jensen, and I'm here to represent Taro Schrackle and the Schrackle Construction Company. Now, just from this case is basically a driver who hit a passenger. Does anyone feel just from the description they cannot be a good juror? Nobody? Silence. All right. Now, the plaintiff described preponderance of the evidence. Does anyone have any questions about it? Nobody? It's okay if you don't know anything. I can answer any questions.
Sure, can you describe it just overall?
Yes, juror number 12, I can. Preponderance of the evidence is just, it's not the amount of evidence, but the quality of the evidence that each side presents. So it's basically the quality that you believe from both sides. So if you believe one side over the other one, that's preponderance of the evidence. Just answer it. Okay. Now, who here is a driver? Everyone? Okay. Now, as a driver, do you feel that you have a responsibility on the road? Do you also feel that pedestrians have the same rules? Not the same ones, but rules, after all. Juror number 1, how do you feel about drivers and pedestrians? What are the rules and?
If you're driving, you need to be looking out for the pedestrian and vice versa. If the pedestrian is walking, he needs to be looking out, he or she needs to be looking out for the vehicles as well.
Okay. So both sides have their rules. Now, has anyone had a pedestrian just walk in front of them while you're driving? Juror number 2, how did that instant feel? Can you speak up a little bit? Sorry. Now, do you feel it's your fault or their fault? They just pop out in front of you and you're driving. Just instant. Juror number 4, have you had that happen to you? Are they looking? Cell phone. Okay. Juror number 5, has that ever happened to you? How do you feel when that happens?
It's nerve-wracking because you're paying attention to, you're driving and like, instead someone just out of nowhere pops out and it throws you off.
And they just don't stop. They just keep going, don't they? Yeah. Juror number 6? Yeah? Tell me of an instant that just made you feel like it was at school. Just made you angry, right? Juror number 7, have you ever had that happen to you? And how do you feel when that happens? Now, as a driver and you're driving, what is the most memorable instant where a pedestrian just walked in front of you? The most memorable one.
I was turning right at a red light. They were trying to cross the street.
So you had the red light. Okay. Did it turn green while they're walking? No. Okay. Juror number 8.
Just recently I had someone literally sprint across the street in front of my car.
Now,
It was terrifying.
was it just, were you at an intersection or?
Yeah, I was coming up to an intersection, but they like came from an angle to like run to the crosswalk, and I slammed on my brakes and all the stuff in your car shifts. That was scary.
So they weren't on the sidewalk, they were just on the road. Wow. Juror number 10. Has that ever happened to you? No? Not at all? Never, as a driver? All right. Juror number 11.
It has happened before here.
Oh, okay. Yeah.
But in general, it gets scary when it happens. Instead of like the rider, I think we're responsibility to like look out for that.
Okay.
It happens so much that
Yeah, but if they, have you ever have kept a close eye on your surroundings, but still somebody just walks in front of you and you don't see them?
it happens pretty quiet.
Juror number 12.
As well, share the same sentiment. Basically, you are the driver. You are supposed to always stay alert at any possibility of someone coming in for whatever reason. They could be running away from someone, and it's not planned. That road is there,
Yeah.
so you need to always be alert as a driver.
So you believe that both parties have the responsibility of keeping watch for each other?
Right, they are responsible.
Okay. Do you feel that the driver has more responsibility as a driver?
I think it's kind of comparing apples to oranges.
Okay.
So,
All right. Juror number 1, what is your occupation? Okay. As a police officer, have you ever had an incident where you had to show up and there was a pedestrian? Now, was it the driver's fault or the pedestrian's fault? The pedestrian. Did they just walk out of nowhere or? Nowhere. So the driver couldn't see them. Okay. Now let's see here. Now, has anyone ever been in a jury before? No. No one. Okay. And is anyone a previous contractor, business owner, entrepreneur? Nobody? Okay. And let's see here. Now, would anyone pay any money for any incident, even if it wasn't your fault? No? Why not, jury number 1? Jury number 2, do you feel the same way? Jury number 3? Jury number 4, feel the same way? Jury number 5? Jury number 6? Jury number 7? Jury 8? Jury number 9? Or 10? Jury number 11? If there was an incident and you had to pay damages, even though it wasn't your fault, would you do that? Now, what if the court didn't have to? What if you were just, conversing with a pedestrian and they just said, oh, it's your fault, you did it? No? Jury number 12?
Depends on the amount of damage you go.
No, it's not your fault.
Still have to, you hurt somebody, you still have to have repercussions for that. I believe that.
Jury number 11, do you agree with him?
Always with the situation, to some degree.
Jury number 10? You don't agree? Jury number 8, do you agree with jury number 12?
No, I don't think I would agree.
Jury number 7? Jury number 6? Jury number 5? And now, just from hearing the description and the questions, who feels that they could not be a good juror for this question, for this incident? No one? Now, jury number 3, I have one question for you. What do you do for a living?
Professional driver.
You're a driver. Do you drive commercial vehicles or just commercial? Now, have you ever had an incident where you're driving your truck at work and somebody just walked in front of you? And you have a big truck, don't you? And somebody just pops out of nowhere. Do you have time to react?
Yes.
Okay.
You have to be aware of what's going on around you.
Okay.
It's not your fault.
Okay. All right. Jury number 2, do you agree with jury number 3? Jury number 1? Okay. Jury number 4? All right. Well, those are all the questions I have for you guys. Thank you, ladies and gentlemen, for coming out and helping us with this. Thank you.
Okay, plaintiffs in defense. Approach the bench, please. All right. To the attorneys in this case, I'm going to give you 3 minutes to make your strikes. And ladies and gentlemen, if you will just remain in your seats. That's okay. When the attorneys are ready, please turn in your strikes to me. And oh, whatever you need to do. Yeah, go ahead. That'll give us just a few minutes, okay? Well, check with Dr. Benson real fast, okay? Because he's in charge of that. Once you do that now, if you don't mind, yeah. Yeah, 8 is, 8, you don't consider 8. Consider number 8, he's for cause. I did not ask you guys if you had any motions before you turn in your strike, so I'm going to ask you now if you have any motions regarding any of the jurors. Do you know what I'm talking about? Okay. Okay, so then your answer will probably be no, but that's okay. But I just want to ask the question. I should have asked it already. That's my fault. Okay. I just don't know. It's hard to know how far you are. So, okay. That was my error. Okay. All right. Are we ready to proceed? Go ahead and, well, let me ask you before you turn in your strikes. Does anybody from either side have any motions for me at this point?
No, ma'am.
Any matters you wish to discuss before turning in your strikes? None from the plaintiff, none from defense. Okay, go ahead and turn in your strikes, please. Okay, have a seat, and I will be with you just a minute. Okay, just want to make sure I had it correct. All right, ladies and gentlemen of the panel, when I call your name, I'm going to ask you to rise and move over into the jury box, which is to my left, to your right. Those of you remaining, you have not been selected for this jury. You may need to call in tonight. If you were given a telephone number, call after 8 o'clock, and they will let you know if you need to report this week or next week for another jury panel, okay? So with those instructions, when I call your name, please rise and move over. And to everybody else, thank you very much for your service. Okay, Sauletta, Adela Kellum, Sierra Casey, Sarah Katropia, Sepeda Javert, Jared Keeling, and if you will remain standing when you find your seat. Is there any objection or comment from the plaintiff? Does that match your strikes?
Your Honor, jury number 9 didn't come
Oh, okay. So we only have 1, 2, 3, 4, 5. We only have 5. Okay. All right. Go ahead and be seated, ladies and gentlemen. Let me see the lawyers. many strikes did he give y'all? Okay, so did y'all circle the ones you want to keep, or did you write the, I think I'm not reading this correctly. Oh, and I did okay, great, and then I struck, I do my, okay. Okay, so I did this wrong, huh? Okay, y'all stay up here. Let me make sure I get this right, okay? So juror number 1 is good. Juror number 2 is good. 3 is a strike from both sides. 4 is a strike, right? Okay, 5 is a strike. Right? Oh, it was not a strike. It's not, okay. Okay, 6 is a strike. Okay, 7 is a strike. I did this totally wrong. Okay, 9 is not here. 1, 2, 3, 4, and 10 is a strike. 11 is good. And 12 is a strike. 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. Okay. Any objection to a jury of 5? No objection from a jury of 5? No objection from a jury of 5. Okay, we are, ladies and gentlemen, I beg your pardon. Would you go ahead and return to your seats, and I will recall. All right, wait, you guys stay here. Okay, court reporters, we are currently outside the presence of the jury, all right? Okay, as it turned, just for the purposes of the record, we have a situation where we have 5 jurors instead of 6. Is there any objection from the plaintiff for the purposes of this trial and the record to 5 jurors rather than 6?
No, Your Honor.
No objection from the plaintiff. Is there any objection from defense?
No, Your Honor.
No objection. Okay. All right. Be seated. Okay, ladies and gentlemen of the panel, I beg your pardon for the confusion. I'm going to call your names once again. Mr. Letta, you made it again. Mr. Letta, please, number 1. Okay. Adela Kellum, you've made it again. Let's see if I got this right. Okay, Masid Coroni, Maria Schoner, and Kenneth Kettler. Okay, and ladies and gentlemen of, yes, sir. 2, 3, 4, 5. Oh, okay. All right. Well, we are outside the presence of the jury. Madam Court Reporters, if you will please record this. Is there any objection from the plaintiff to 4 jurors? Yes. Okay. Go ahead and voice your objection.
Your Honor, we were under the impression at the beginning of the trial that we would have 6 jurors. Now we have 4. We went down to 5 now. It's 4. We feel that we should at least have 5. How we initially agreed when we were all together.
Okay. And what is the? Can you? So I understand that was your agreement, but can you tell me what harm, how that's putting you at a disadvantage, and how it's unfair?
Because to hear the story that we have to present today, I feel like the more different people that are up on the stand will be able to put their minds together and come up to a decision together from putting their input from different backgrounds to make a decision.
Okay. All right. How about the defense? Do you have any objection?
We do
All right. So is there a motion from the plaintiff? Do you move for a mistrial at this point? All right. Hearing no motion for a mistrial, I'm going to overrule your objection and proceed. All right. Ladies and gentlemen of the jury, if you will stand, please. Well, actually, I'm sorry. Wait just a second. Let me give you some instructions first. You're going to get a lot of exercise, I can tell, this evening. All right. Please do not, I want to give you some instructions that I want you to follow, all right? I do not want you to speak to any of the attorneys or any of the witnesses involved in this trial. You are only to speak to each other and to the bailiff who is sitting to your left over there in uniform, all right? He's going to be the person who meets with you and directs you wherever you're supposed to go. I do not want you to use any outside information that would have any sort of influence on the way you hear evidence in this case. And don't read any newspapers, anything you may have heard on the radio, disregard. Please do not use your cell phones or any other device you might have to access information. Do not talk about, when you're out deliberating or at any other time, do not talk about any personal expertise that you might have. Confine any deliberation or any discussion to the evidence that is actually admitted in this case. Okay, those are your instructions. So I'd like you to go ahead and raise your right hand and be sworn. Do each of you swear to follow the rules of this court and to reach a verdict that is based solely on the evidence that is admitted in this trial? Okay, we're ready to proceed. All right, may I have an opening statement from do you wish to make an opening statement from the plaintiff? All right, you may proceed.
Test. This was the sound that Jeffrey Potter heard at his door when his life was shattered with an unbearable tragedy. He was told that his wife, Catherine Potter, was in critical condition at the hospital. When Jeff arrived in the emergency room, he saw his wife, Catherine, struggling for her life. During the next 5 days, Catherine was clinging on to her life, and all Jeff saw was pain and agony. And all of this happened for one reason. He was by her bedside, hoping and wishing for a miracle. But on the 5th day, all hope was lost because she died. And all of this happened because of the distractions of one man, Charles Schrackle. My name is Jennifer Gerhard, and my colleagues and I, Mrs. Scott and Mr. Tague, represent the plaintiff, Jeffrey Potter, and he's Catherine Potter's wife. And we're here today because Schrackle was distracted and caused Miss Potter's death. November 30th started like any other day. The defendant was going from construction site to construction site. Then he went to a supply store, just wasting time. And because he wasn't very good at time management, he was about to lose a big job with a big company. In fact, the general contractor summoned Mr. Schrackle for a very important meeting at 3:30 on the day of the incident. At about 3:10 p.m., he left the supply store, running late like always, and he called Mr. Poe, who is the general contractor, in a frenzy to tell him that he was running late again. 3:30 p.m. was drawing near, and as he was approaching the intersection, he didn't stop. He just slowed down, and he allowed a car coming from the opposite direction to pass before him before he made the left turn. As he was turning, he looked to his right because there were school children to the right, and that's when it happened. That's when he hit Mrs. Potter at the crosswalk with his 3,000-pound truck. According to witnesses, they saw her body being carried on the hood of the truck. Another witness saw her body flying in the air in front of the truck. One witness even saw her flying in the air and saw when Catherine's body and her head fell and slammed into the pavement. Then the truck ran on top of her. He didn't even realize he hit her because he was looking everywhere else except in front of him. All he was thinking about was the meeting because he didn't want to lose the job, because he didn't want to be late, because losing the job meant he would lose money. Schrackle's distractions caused Miss Potter's death. Today you will hear Mr. Schrackle's side of the story, but despite his obvious responsibility, he will try to convince you otherwise. The defense will try to distract you from the truth by focusing on what Mr. Potter did after his wife passed away. We expect the defense to accuse Mr. Potter of having skeletons in his closet. That's why we want to be truthful with you. We want to be open. We want to be honest. I'm sure if any of us were in Jeffrey's position, we would have a few things in our lives that we would be vulnerable in, a few areas in our lives. And this widow doesn't want to hide the fact that he was lonely after his wife's death, that he went home to an empty home without his companion, without the love of his life, without anybody there, without his soulmate. And I ask you, is there a set time to move on? I mean, for somebody it could be 5 years, for somebody it could be 2, or maybe 1 year, or maybe 6 months. Would we prefer a widow to lose their reason of living, or would we rather see them try to move on? The answer is yes. We'd like to see them happy. And because he was grieving Kathy's death, he would seldom go out except to teach his class. And during this grieving process, he slowly developed a personal relationship with a former student named Shara Tobias. He even went on a week trip with her to the Caribbean to continue to live life, to try to forget the pain, the memory of his wife struggling for her life in the hospital. Who can blame him for trying to forget the memory of his wife's suffering at the hospital before she died, even if it was for 1 week? We cannot sit here and point the finger, because if we were in his position, we wouldn't know how we would react. But we anticipate that the defense will put a microscope on this issue as a sideshow, as another distraction, and even say that his marriage was in jeopardy before she died. It's true that Jeff and Catherine sought a counselor to help with the issues, but there's no perfect marriage out there. The fact that he sought a counselor was not because they were at the end of their marriage, but it demonstrated that they loved each other and were committed to their marriage enough to see the future together. But now, they will never have the chance because the defendant took Catherine's life away from Jeffrey Potter. Even as you hear the defense put this widow's life under a microscope, this does not make Schrackle less responsible for this wrongful death. We also anticipate that the defense will speculate as to the reason why Catherine was struck. We expect the defense to go as far as to blame Catherine for Schrackle's carelessness. This is why it's important to weigh the evidence. Ms. Scott spoke in Voir about the preponderance of the evidence. And this is not a criminal case where you have to decide beyond a reasonable doubt. This is a civil case. And all that simply means is that more likely than not, the defendant's wrongful action caused Ms. Potter's death. We only need 51%. We believe that the evidence will show you that the defense was not only distracted, not only was he on the phone, not only was he looking to his right, not only was he looking everywhere else, but that he caused Ms. Potter's death. And because of her death, Mr. Potter suffered financially, he suffered emotionally, he suffered mentally. And the only way to resolve this, the only way we can do this, is for Schrackle to take responsibility and to award Jeffrey Potter $2.5 million. Now, don't let the amount of money distract you. There is no value on Kathy's life, but this will send a loud message to Schrackle, to his company, so that another life will not be taken. And as you walk into the jury room, we believe you will be able to find the defendant 100% responsible for his distractions, for his negligence. And we know that you can do it with confidence, knowing that justice was served. Thank you for your time.
Does the defendant wish to make an opening statement at this time?
Yes, Your Honor, we will.
Okay, you may proceed.
for exercising your rights as a citizen here to ensure that we find justice today. All of you are now a major component in a decision in this horrible accident. Today you will hear a story about a woman who wasn't in a crosswalk and it cost her her life. Now all of us were taught at a young age, throughout growing up, certain rules for our safety. Things like, don't play with fire, you might get burned. Always look both ways across the street, you might cause an accident. And always use a crosswalk so that you remain safe. Today you'll hear about a story. Now all of us were taught at a young age and throughout growing up rules for our safety. Let me take you through Charles Schrackle's days. He's checking emails, the course of project plans, visiting job sites. Later in the day, around 3 o'clock, he goes to pick up building supplies for one of his jobs. While leaving, he happens to realize it's a beautiful day outside. He notices that he's running a little bit late for a meeting and makes a phone call to a client to let him know that he's running about 10 minutes behind. As he heads to the city, comes up to an intersection, he notices that there's some children at the corner near the crosswalk. The children seem to be excited, just out of school and all, so he keeps an eye on them just to make sure that they do not run out in traffic. As he makes his turn past the intersection, the most horrible thing happens. Someone steps out of nowhere in front of his vehicle. There's no way of stopping this horrific accident from happening, and this is a reality Charles Schrackle lives with every day. Now, due to circumstances, there's an awful truth, that even when you follow the rules of the road and careful with your decisions, accidents will still happen. This is something we cannot help, and this simply is a case of an unfortunate and unavoidable accident that no one could have foreseen coming. There will be testimony today from several different witnesses that will tell a story. After you hear from everyone and all the evidence is presented, it will be the same story. You will hear that Charles Schrackle did not apply his brakes until the accident happened. This only affirms that he did not see her in the responsible area where you would find a pedestrian. It may come into question that my client was on a cell phone at the time of the accident. There's no evidence to support this claim. Also, that the sun was extremely bright for that time of day and in a low position in the sky. These factors will not change regular habits of a cautious daily driver. You will hear that Mrs. Potter may have been in the crosswalk or may have started her way down the median between both lanes of traffic. This is an action that no driver... We will show that she did in fact alter from her original direction and walk in front of oncoming traffic. This is an action that no driver should ever have to anticipate. Mrs. Potter took herself out of the safe zone and it cost her her life. There is a duty of care every driver owes to other drivers and pedestrians, that they follow the rules of the road. The duty owed by the pedestrians is the concern in this case. Mrs. Potter had the duty to be in the crosswalk and she wasn't. If she was, we wouldn't be here today. We ask that you listen to all the evidence that is presented from both sides. We have all had a situation of a close call, whether it was with a vehicle, an animal, or even possibly a pedestrian. We all know that there's no way to react to something or someone that you never see until it's too late. Charles Schrackle reacted as any reasonable person would. Mrs. Potter wasn't in the crosswalk, and it cost her her life. This is a civil suit and the unfortunate death of Mrs. Potter. We'd like to emphasize that Charles Schrackle did not cause this accident. This was not Charles Schrackle's wrongdoing, and he must not be held liable for the actions that he could never have anticipated. Thank you. Thank you, Your Honor.
Is the plaintiff ready to call your first witness?
Yes, Your Honor.
Okay.
You called Jeffrey Potter to the stand.
Has this witness been sworn?
Yes, Your Honor.
Okay.
No, Your Honor.
Okay. Mr. Potter, raise your right hand. Do you swear to tell the truth, only the truth, nothing but the truth?
I do, Your Honor.
Okay. Take the witness stand, please.
Your Honor, may I proceed?
Yes, you may.
Thank you. First off, I just want to say I'm so sorry for your loss.
Thank you.
Could you introduce yourself to the jury by stating your name?
My name is Jeffrey Potter.
And what's your occupation?
I'm a physics professor at Nita University.
And where do you live?
4920 Thorndale Drive. It's the same house Kathy and I lived in before she died.
And what's your connection to this case?
I'm Catherine Potter's husband.
Jeff, could you tell us why you're here today?
I'm here because Charles Schrackle was distracted and he caused my wife's death.
How did you and Catherine meet?
We met in 1998. We were both part of the same community chorus.
Would you turn to Exhibit 5 in your exhibit book, please?
Yes.
Your Honor, plaintiff moves to offer Exhibit 5 into evidence.
Would you identify Exhibit 5, please, through your witness?
It has already been agreed to.
But identify it for the record. What does it depict without going into the contents of it? What is it?
Yes, ma'am. Yes, Your Honor. Do you recognize the exhibit?
Yes.
And what is it?
This is a photo of Catherine before she died.
Your Honor, plaintiff offers Exhibit 5 into evidence.
Okay, and this exhibit has been tendered to the other side, and there being no objection, it being by agreement, it's admitted.
Oh, may I display the exhibit, Your Honor?
Yes, you may. You may publish Exhibit 5 to the jury for their inspection.
Thank you. Now, what's your reaction today as you're looking at her picture?
It reminds me of all the times we spent together in the garden. It just reminds me of how much I love her.
Do you have any children?
No, I don't.
Did you want children?
We tried to have children, but it never worked out.
Could you describe Kathy's work history?
Yes, before we met, she was a high school teacher, and shortly after we met, and I believe in 1998, she began to work at Technosoft Incorporated.
And did she like working there?
Oh yes, she loved it. The work left her very fulfilled. I was very happy for her.
Okay, and although both of you were busy at work, tell me your duties at home. What did you contribute to the household?
I did most of our travel planning as well as any cooking and repair work around the house. Kathy did most of the laundry as well as handle any financials. She had a real eye for the stock market.
Was there anything that both of you liked to do?
Yes, we both loved to do the gardening.
And this picture was taken in your garden?
Yes, it was.
Now, you mentioned that you planned to travel. Was this another hobby both of you enjoyed?
Yes.
When did you usually travel?
We would normally travel during the summers when I was off. Kathy would take a few weeks off and we'd see the world together.
And what were some of the places you visited?
Tuscany and Umbria were our favorites. We loved Italy.
And did this help your relationship grow?
Yes, we had a near perfect relationship before Schrackle took her life.
Now, despite your busy schedules, did you spend time together other than travel?
Yes, whenever we could, we would walk through Sen Park together and catch a movie whenever we could.
Now, you said you had a near perfect relationship with Kathy. Could you explain that?
Well, no relationship is perfect, but we always managed to work through our difficulties. Before she died, we were actually seeing a marriage counselor, but I was always very confident that we could work through our problems.
Now, let me take you to November 30th, 2010. Where were you?
I was in my office speaking with another student, Cheryl Tobias.
And then what happened?
There was a knock on the door. The departmental secretary told me that Kathy had been in a very serious accident.
And what did you do next?
I immediately rushed to the hospital.
And when you arrived at the hospital, was she conscious or unconscious?
She was unconscious, and shortly after I arrived, she was moved into the intensive care unit.
How did she appear there?
She always appeared to be in a great deal of pain.
And why do you say she appeared in pain?
She was always moaning and just looked like she was in pain.
And how many days was she at the hospital?
About 5 days.
Did you ever leave her bedside?
No, I even had people bring me clothes and things, so I never had to leave her.
And how are you feeling during this time?
I kept praying for a miracle that never came.
What was she treated for that caused her death?
She was...
Objection, Your Honor. Facts not in evidence.
Response?
You're not. I'm going to enter in an exhibit. I'm going to lay the foundation, Your Honor.
Okay, well, sustained at this time.
Could you turn to exhibit 26?
Yes.
Without describing the content, what is it?
This is a statement I received from the Needham Memorial Hospital on December 7th, 2010.
And how do you recognize it?
I received the statement from Needham Memorial Hospital on December 7th, 2010.
Your Honor, plaintiff moves to offer exhibit 26 into evidence.
Would you publish it to plaintiff's defense counsel, please? Or do they have a copy of it?
Yes, Your Honor, it's the same exact exhibit that they have.
Okay. Any objections?
No, Your Honor, we don't.
Admitted.
Could you read the statement that says what she was treated? Oh, sorry. Could I display the exhibit, Your Honor?
Yes, you may. Publish it to the jury.
Okay, publish. Your Honor, may we display the, sorry. Could you read what she was treated for in the statement?
Yes. Kathy was treated for severe head trauma, brain injury, and a fractured skull, all of which were the result of being struck by a moving vehicle. She suffered from intermittent consciousness, and they performed surgery to relieve pressure in her brain.
And Kathy died December 4th, 2010?
Yes, she did.
And then what did you do?
I went back to our empty house to plan her funeral.
And the funeral was December 11th, 2010?
Yes, it was.
Could you turn to Exhibit 27 in your exhibit book?
Yes.
Do you recognize it?
Yes, I do.
Without describing the content, what is it?
This is the invoice I received from the Odell Funeral Home on January 12th, 2011.
Your Honor, we offer exhibit number 27. Your Honor, we offer exhibit number 27 into evidence.
Any objection?
No, Your Honor.
Admitted.
Your Honor, may we display the exhibit on the board?
Yes, you may.
Now, how did her death affect you?
Well, I was just so alone for about 6 months after.
Objection, Your Honor, asked and answered.
Overruled.
For about 6 months after she died, I didn't really do anything. I don't think I left the house except to teach.
Did you seek any kind of help?
Yes. I visited with our marriage counselor a few times after she died.
Did you do anything else to cope with Kathy's death?
Yes. In late spring 2011, I began a relationship with Cheryl Tobias.
And this is the same person present in your office
Yes.
when you heard about Kathy's death?
Yes.
And what was she doing in your office?
At the time, she was my teaching assistant, so we were just having a meeting.
And were you developing a personal relationship with her
No.
while you were married?
No.
While Kathy was alive, were you faithful?
Yes, I was.
You said, when did you begin the relationship again?
Late spring 2011.
And why do you think you developed a relationship with her?
Well, we both had mutual interest in traveling. We actually took a trip together to Martinique in June 2011.
And can you turn to exhibit number 32 in your exhibit book?
Yes.
Could you identify that for the jury?
This is a picture of Cheryl and I in Martinique.
Is it a true and accurate photograph of your trip together to Martinique?
Yes.
Your Honor, we offer exhibit 32 into evidence.
Any objection?
No, Your Honor.
Admitted.
Your Honor, may we project the picture?
You may.
And this is you and Ms. Tobias on your trip?
Yes, it is.
And this was how long after Kathy's death?
About 7 months.
And how many days were you in Martinique?
6.
Did you pay for the trip?
Yes, I did.
Could you turn to exhibit 29 in your exhibit book?
Yes.
Do you recognize it?
Yes, I do.
Without explaining the content in it, without describing the content, what is it?
This is the ticket receipt I received from the Nita Travel Company.
Your Honor, we offer exhibit 29 into evidence.
This has been agreed, correct, by defense?
Yes, Your Honor.
Admitted.
Your Honor, may we display the exhibit?
Yes, you may.
And this was your plane ticket that you received it was issued to you on May 30th, 2011?
Yes.
And if you see on the very bottom, it was charged to your account?
Yes.
Turn to exhibit 30 in your exhibit book.
Yes.
Without describing the content, what is it?
This is Cheryl's ticket receipt from the Nita Travel Company.
Your Honor, we offer exhibit 30 into evidence.
Okay, that's been agreed by defense, correct?
Yes.
Admitted.
Your Honor, may I project the exhibit?
Yes, ma'am.
Thank you. And this is Ms. Tobias' ticket, correct?
Yes, it is.
And it was also charged to you?
Yes.
Now, while you were on the trip, did you do any activities?
Yes, we took a champagne cruise. We visited the day spa a few times, and we had a few massages. It was a very luxurious trip.
And when you came back from the trip, how did you feel about your relationship with Ms. Tobias?
After the trip, I realized that the relationship didn't really leave me fulfilled, and it just wasn't like what I had with Catherine. Catherine and I were soulmates, and that only really happens once in your life if you're lucky.
Do you think Ms. Tobias felt for you because she was there when you received news of your wife?
I can't really say.
Are you still in a relationship now?
No, I am not.
When did you end the relationship?
In late January 2012.
And your relationship only lasted 8 months.
About
Right.
8 months, yes.
And what was the basis of ending your relationship with her?
I just couldn't move on to another long-term relationship after Catherine died.
And will Ms. Tobias benefit from this lawsuit?
No, she won't.
And when you go home today, what will you go home to?
I'll go home to our empty house.
Your Honor, we pass the witness.
Any cross?
Yes, Your Honor.
Proceed.
I'm sorry for your loss, Mr. Potter.
Thank you.
You stated that Mr. Strackle was distracted at the time of the accident, correct?
Yes, I did.
How would you know this? Were
I
you
don't-
at the accident?
No, I was not.
Where were you at the time of the accident?
I was in my office at Nita University.
Okay, thank you. Mr. Strackle, can you please call your attention to exhibit number 31?
I am not Mr. Strackle, counsel.
I'm sorry. Excuse me, Mr. Potter. I call your attention to exhibit number 31.
Yes, you may.
Do you recognize this exhibit?
Yes, I do.
What do you recognize it to be?
This is the receipt I received from the Martinique Princess Hotel.
Is this an accurate depiction of the charges you had?
Yes, it is.
Your Honor, the defense offers number exhibit 31 as evidence.
I believe, okay. This has already been agreed by plaintiff, so admitted.
Your Honor, can we publish exhibit 31 to the jury?
Yes, Mr. Johnson.
All right, Mr. Potter. What is the date of the day you arrived at the hotel?
6/14/2011.
What was the date you and your wife were married on? Do you not remember this, Mr. Potter?
June 15th.
Okay, thank you. So let me get this straight. 6 months after your wife deceased, you went on a trip around the same time of your anniversary. Is that correct?
Yes, it is.
What anniversary would this have been?
This would have been our 12th anniversary.
Would have been your 12th anniversary? All right, Mr. Strackle. Potter, excuse me. Let me call your attention to exhibit number 42. Mr. Potter, do you recognize this exhibit?
Yes, I do.
What do you recognize it to be?
This is the deposition I took.
You met with your attorneys and created this deposition, correct?
Yes, I did.
Okay. And while you were making this deposition, a court reporter was present?
Yes.
And she administered you an oath that day?
Yes, she did.
An oath to tell the truth, the same one you took today?
Yes.
All right, thank you, Mr. Potter. Can you please read?
Objection, Your Honor. It's not, he hasn't admitted it.
Sustain.
Your Honor, the defense offers exhibit 42 as evidence.
This exhibit I show has been agreed already by both parties. Is that correct?
Yes.
Admitted.
Thank you. Mr. Potter,
Yes.
let me call your attention to page 3 of your deposition.
You said page 3?
Correct. You stated earlier that you didn't have a personal relationship with Cheryl Tobias, your assistant. Is that correct?
No, she was my student at the time, so I had a professional relationship with her.
Okay. Can you please, actually, in your deposition, you stated that, yes, she and I had developed a personal relationship since Kathy's death. Is that correct?
Yes.
So were you in a relationship with her? Yes or no?
Before Catherine died or after?
Both.
Before she...
Were you in a relationship with Cheryl Tobias?
Objection, Your Honor. Asked and answered.
Overruled.
Before Catherine died, I had a professional relationship with Miss Tobias. After she died, in June after she died, I developed a personal relationship.
And what was the day your
with-
wife died on again?
She died on December 4th, 2010.
Thank you, Mr. Potter. Now, you stated that you took this trip to Martinique. What day was this again?
I believe... I'm sorry, counsel, I can't remember the day we left.
Okay. Mr. Potter, isn't it true that you and your wife had a complicated relationship at home?
Like any couple would.
Okay. Mr. Potter, isn't it true that you wanted her to retire from her job?
We had spoke about retirement, but I don't ever remember Kathy agreeing
Thank you,
to
Mr. Potter.
retirement.
Your Honor, defense passes this witness and reserves the right to recall if the need arises.
Any redirect?
Yes, Your Honor.
You may proceed.
Now, the fact that Kathy talked about retirement, did it threaten your marriage in any way?
No.
And the fact that your 12th anniversary arrived, were you still grieving during this time?
Yes, I was. I would say I was particularly vulnerable around the time of our anniversary.
So let's. The relationship with Cheryl Tobias was after Catherine's death.
Yes, it was.
No more questions, Your Honor.
Recross?
Your Honor, can we publish exhibit number 32 to the jury again?
32 has been admitted. Yes, you may. Call your next witness.
Oh.
Wait.
Oh, do you have recross?
Yes, yes.
Oh,
Yes,
okay.
Your Honor.
All right.
Your Honor, may I step over and lower the screen? I think that'll be the jury.
Please do. We are outside the presence of the jury. Since we are having a moment, counsel, be careful not to speak when a witness is speaking, okay? Because the reporters cannot take down what two people are saying at the same time.
Yes, Your Honor, I
So,
apologize.
not at all. Okay. Are we ready?
Yes, Your Honor.
We are back inside the presence of the jury.
Okay, Mr. Potter, you said that during the time this photo was taken, you're in grieving?
Yes.
Correct. Okay. Do you look in grieving in this photo? Do you look happy, sad, mad?
Objection, Your Honor. He's speculating.
Overruled.
I don't know.
You don't know. By judging by this picture in your face, you can't determine whether you're happy, sad, mad, in grieving?
You can't be depressed about something and happy at the same time, counsel.
I'm asking you to choose one.
In the picture, I look happy.
You were happy that day, correct?
I was happy when that picture was taken.
Okay, so you were not in grieving over the process of that vacation, correct?
I can't remember.
If you're happy in this picture, how can you be in grieving?
I don't know.
Mr. Potter, that's one heck of an assistant. Your Honor,
Your Honor, that was uncalled for. Your Honor, I object. That was uncalled for. That was.
Do you object to the sidebar comments?
Yes.
No sidebar comments, Mr. Johnson.
Your Honor, the defense passes witness.
Any redirect?
Yes, Your Honor. Have you experienced the grieving process before?
Yes, I have.
Oh, before Catherine's death.
Yes.
Before Catherine's death, did you experience the grieving process before? Before Catherine died, do you know the experience of grieving?
Yes.
Okay. Were you ever sad because somebody passed away before Catherine died?
Your Honor, facts, not an evidence.
Overruled.
Have you ever lost a loved one before?
No.
So you wouldn't know how you would react.
No, I would not.
So this picture, you could be happy,
Yes.
but then at the same time, you could be grieving.
Yes.
Because nobody can really understand how somebody can grieve, correct?
Yes.
Your Honor, no more questions.
Any cross?
No, Your Honor.
Okay, call your next witness, please.
Your Honor,
Okay, Daniel Sloan. Has this witness been sworn?
No, Your Honor.
Mr. Sloan, please stand and raise your right hand. Do you swear to tell the truth, only the truth, and nothing but the truth?
I do.
Okay, have a seat. You may proceed.
Thank you. Could you please state your name for the jury?
Daniel Sloan,
And where do you live, Mr. Sloan?
Nita City, Nita.
And what is your connection to this case?
I was Catherine Potter's boss at Technosoft Inc.
Mr. Sloan, could you tell us a little bit about Technosoft?
I'm the CEO and principal shareholder. We're a small company of about 50 employees, and we develop software that's used in high-tech manufacturing processes.
Thank you. And how long had Miss Potter been an employee of yours?
We hired Catherine in 1999. She worked for us for 11 years.
And what was her position at Technosoft?
Technology training specialist.
And Mr. Sloan, could you tell us, was Miss Potter a good employee?
She was one of the best employees that I had. She worked very hard. She consistently received raises for having top performance. We actually gave her a bonus of $2,000 as a thank you for all of her hard work in January of the year that she was taken from us.
And what was Miss Potter's salary?
She started at $34,000 a year. By 2010, she was making $85,000 a year.
And did Miss Potter have any benefits working at Technosoft?
Yes, we provide our employees with a benefits package worth 20% of their salary.
And this was in addition to their salary?
Yes, this is added to it.
And what kind of benefits did Miss Potter receive?
Our benefits package included contributions to the retirement fund, health insurance that included dental coverage, disability insurance, and life insurance.
And this was all a part of the 20%?
Yes, this was. It was worth about $17,000 to her in 2010.
Thank you. And were any of the bonuses she received, would that be considered a part of benefits?
No, the bonuses were in addition to benefits and salary.
Thank you. Did you have any plans to promote Miss Potter in the near future?
Yes, I was preparing her for the position of executive vice president.
And I said in the near future. How near in the future would that have been?
Within about 3 years.
Thank you. And what is the salary of an executive vice president?
In that position, one can earn from $120,000 to $150,000 per year, and it's also possible to earn a bonus of around $10,000 each year for good performance.
Thank you, Mr. Sloan. And why did you want Miss Potter to have this position?
Our company is expanding, and I thought she would be perfect for that role. She had the technical skills, and she had a wonderful ability to work with people. She was just one of the best employees I had, and I've really missed her.
Your Honor, plaintiff passes the witness.
Any cross?
Yes, Your Honor.
Okay, proceed, Mr. Johnson.
Now, Mr. Sloan, isn't it true that you only speculated as to she would receive this promotion? Is that correct?
It was an idea of mine.
Okay, so it wasn't for sure she was going to receive this promotion, correct?
It was not sure yet.
Okay. Mr. Sloan, did you have any idea of the complications to their marriage at home between Mrs. Potter and Mr. Potter?
No.
You did not?
No, sir.
Did she ever bring up the topic of you about retiring early?
No, sir, she did not.
She did not bring you the topic of retiring early?
No, sir.
All right. Mr. Sloan, I call your attention to exhibit number 43.
Yes, sir. Yes, sir.
Do you recognize this exhibit?
Yes, sir.
Do you remember sitting down with your attorneys to make this deposition?
Yes, sir.
And a court reporter was present?
Yes, sir.
And she administered you an oath, the same oath you took here today, to tell the truth?
Yes, sir.
All right. Your Honor, the defense offers exhibit 43.
I show that this exhibit has previously been agreed. There being no objection from plaintiff, it's admitted.
Mr. Sloan, can you please read on page 1, line 30 of your deposition?
Catherine did tell me that her husband, Jeffrey, was always after her to retire early.
But you just previously stated that she didn't mention anything about retirement to you?
Your Honor, this is all yours.
Yeah, sustained.
So, Mr. Sloan, is it true or is it not true that you didn't know about Mrs. Potter early retirement?
No, she never talked about it with me.
She never talked about it?
No, sir.
But in your deposition, you stated that she did. Is that correct? You just read it to me.
Objection, Your Honor. Hearsay.
Well, what specifically do you object to, Mr. Tagg?
The fact that the answer would bring up the same thing that he just had, that was just a standard hearsay.
Anything in the deposition has been admitted already as exhibit number 43 without objection, correct?
Yes.
Objection overruled.
So, Mr. Sloan, let me ask again. Did you or did you not know about the retirement, the early retirement of Mrs. Potter?
She never told me she wanted to retire early.
So are you lying here today, or were you lying when you filled out your deposition?
Her husband wanted her to retire is all I knew about.
Thank you, Mr. Sloan. Your Honor, the defense passes as witness.
Any redirect?
Yes, Your Honor.
Okay, proceed.
Mr. Sloan, so did Miss Potter ever tell you that she was going to retire?
She told me that her husband wanted her to, but that wasn't in her interest.
Could I direct your attention to line 33 of your deposition?
Yes, sir.
And could you read that to me?
Counsel, just to be clear for the record, are we talking about exhibit 43?
Yes, Your Honor.
Okay.
Sorry. Could you read that line for me?
She told me that there was no way she would retire before she was 60.
No question.
Recross?
Mr. Sloan, she wasn't positive when she told you she would retire at 60, correct? She was only speculating as to her retirement because she hadn't retired yet, correct?
No, she hadn't retired.
Okay, thank you. Your Honor, defense.
Redirect?
No, Your Honor.
Okay, Mr. Sloan, you may step down, sir. May this witness be excused, or does he need to be on standby by the plaintiff?
What-
May be excused, or do you
He's
wish to?
excused.
Okay, how about the defense?
Yes, sir.
All right, Mr. Sloan, you may be excused. All right, and next witness?
Plaintiff calls Dr. Roberta Lynn to the stand.
Dr. Glenn? Has this witness been sworn?
No, Your Honor.
Dr. Glenn, please raise your right hand. Do you swear to tell the truth, only the truth, and nothing but the truth?
I do.
Okay, have a seat, please. You may proceed.
Thank you, Your Honor. Could you please state your name for the jury?
Dr. Roberta Glenn,
And where do you live?
Nita City, Nita.
And could you describe to the jury your occupation?
I'm a professor at Goldman Sachs.
And what do you specialize in as a professor?
Labor organization and microeconomics.
And how long have you specialized in these fields?
Approximately 17 years.
And in those 17 years, have you published any scholarly articles or books?
Yes.
And how many books?
2 books.
And how many scholarly articles?
I've published 5 articles.
And how many wrongful death cases have you been involved with as an expert witness?
24.
And in what capacity?
I've testified as an expert witness for the plaintiff 21 times and 3 times for the defendant.
And as an expert witness in wrongful death cases, what areas of microeconomics do you specialize in?
Labor organization.
Thank you. And more specifically, what do you provide as part of your expert opinion?
I bring expertise about wrongful death, loss of wages, and any negligence cases.
And could you tell us your connection to this case?
I was hired by the firm of Gerhard, Scott, and Teague.
Now, could I direct your attention to Exhibit 44 in the trial notebook?
Yes.
And do you know what this is?
Yes.
Without revealing the content, could you tell me what it is?
It's a copy of the expert report that I compiled regarding the Catherine Potter wrongful death case.
And has it been altered in any way?
No, it has not.
Your Honor, plaintiff offers Exhibit 44 into evidence.
I show this exhibit has previously been agreed to by both sides. There being no objection, it's admitted.
And Your Honor, may I publish page 5 of Exhibit 44 for the jury's inspection?
You're going to have to identify page 5 better. My numbering is
Okay.
different.
Roberta Glint, could you turn to page 5 of Exhibit 44?
Yes.
And do you know what this is?
Yes.
And without revealing the content, could you tell me what it is?
It's a formula for how I decide my methodology for deciding damages in wrongful death cases.
And hang on.
Mr. Tagg, this exhibit has already been admitted into evidence, but I'm counting 5 pages, and I show it's page 43. Do you have another page number?
Yes, that is the page I was.
Is page 43 your page 5?
Yes.
Okay, go
yes.
ahead and publish it.
Okay. Your Honor, may I publish the?
Yes, sir.
And based on your expert opinion, how many more years did you determine Ms. Potter to work?
15, and I assessed this I based my opinion upon Mrs. Potter's death at age 45 until her projected retirement age at 60.
And how did you make this determination?
My decision was based upon data I collected from the U.S. Department of Labor.
Did anything else help you with this determination?
Other depositions and testimony given by other witnesses compiled by your law firm.
Thank you. And with this determination, what would Ms. Potter earn if she had worked until the age of 60?
Approximately $1.9 million.
Now, looking at this report, I see that her income increased over time.
Yeah.
And what is the explanation for this?
I have a set methodology that I use from prior cases where I've testified as an expert witness, and based upon the victim's expected growth within the company, such as take months off, and testimony from prior bosses that Mrs. Potter would receive promotion within the next 15 years.
Thank you. And Dr. Glenn, could I direct your attention to Exhibit 26 in the trial notebook?
Yes.
And do you know what this is?
Yes.
And without revealing the contents, could you tell me what it is?
It looks like a summary of a hospital bill from Nita Memorial Hospital.
Your Honor, this exhibit has already been admitted into evidence. May I publish it on the screen?
Yes, you may.
Thank you. And Dr. Glenn, if you could look at the bottom of the report, could you tell me the total amount of hospital bills?
Yes, $107,000. $107,800, as a matter of fact.
Thank you. And could I direct your attention to Exhibit 27 in the trial notebook?
Yes.
And do you know what this is?
A funeral expenses notation.
Your Honor, I believe this exhibit has also been admitted into evidence. Can I publish it on the screen?
Yes, you may.
Thank you, Your Honor. And if you could look at the bottom of the funeral bill as well, and what is the total amount of funeral costs?
$16,500.
Thank you. Your Honor, sorry. Can I get you to turn to page 7 of Exhibit 44?
One moment.
Mr. Tagg, will you give us a
Yeah,
cross-reference?
yes, I was just looking for that. That would be page 47. And do you recognize this?
Yes.
And without revealing the contents, could you tell me what it is?
That's the methodology that I use for compensating
Um, can I get you to turn to page 47 on there? I'm sorry. Could you do you recognize this?
Yeah.
And what is this without referring without saying the contents of the page? Thank you. Your Honor, may this be published to the jury?
Just for clarification, you said page 47. Did you mean exhibit 47?
Exhibit 44, page 47.
Oh, okay. Yes, sir. You may.
Okay, thank you. And looking at this report, could you tell us the total amount of fringe benefits due to Ms. Potter?
Yes, the underestimated amount was $383,000 based upon today's discounted present value.
And how did you come to this determination?
The fringe benefits are based upon 20% of Mrs. Potter's $85,000 annual salary.
And would this also increase over time, like her pay?
According to the U.S. Department of Labor, the projected earnings were to increase over the next 15 years.
Thank you. And could I have you turn to page 49 of Exhibit 44?
Yes.
And could you tell me what this is, please?
Page 49 is a computation of my model of consumption or future expenses of Mrs. Potter.
And this is page 49?
Yes. Yes.
Okay, could you tell me what this is?
The household work contributed by Mrs. Potter.
Thank you. Your Honor, may I project this?
Yes, you may.
Thank you, Your Honor. Now, if I could get you to look at the bottom of this, what is the total amount of Ms. Potter's household work?
$672,000.
And how did you calculate this?
Based upon previous testimony I've given on my methodology and models of use to formulate household work for wrongful death victims.
Okay. And could I get you to look at page 9, which would be 51 of your Exhibit 44?
Yes.
And without revealing the content, could you tell me what this is?
It is the personal consumption of Mrs. Catherine Potter.
Your Honor, may I publish this to the jury?
Yes, you may.
Thank you. And if you could look at the bottom, could you tell me how much personal consumption Ms. Potter would accrue?
Over the next 15 years, I'm expecting I projected her personal expenses would be around $1.4 million.
And how did you come to this determination?
Personal consumption is based upon the model that I've used in previous cases for wrongful death victims. The personal consumption is usually 3/4 of a person's annual income.
Thank you. Can you turn to page 4 of Exhibit 44? And this would be page 41 of Exhibit 44.
Thank you.
And do you recognize this?
Yes, I do.
Without revealing the contents, could you tell me what it is?
It's my methodology model for computing wrongful death damages.
Your Honor, may I project this on?
Yes, you may.
Thank you very much. Dr. Glenn, after making your calculations, what did you determine the total amount of damages to be?
$1.4
And how did you calculate this?
I underestimated the value of Mrs. Potter's future earnings, Mrs. Potter's fringe benefits, Mrs. Potter's future household work, and I had to subtract the personal expenses expected over the next 15 years of Mrs. Potter.
And does this include medical bills and funeral costs?
No, the formula does not.
So based on your expertise and experience, what is the opinion of the total amount owed to the plaintiff in this case?
$1.7 million.
Your Honor, plaintiff passes the witness.
Any cross?
Yes, Your Honor.
Okay, you may proceed.
Thank you.
Dr. Roberta Glenn, you estimate the total loss for the plaintiff in this case for $1.7 million?
Yeah.
Does that include future value of your estimates?
No, that is today's discounted value.
That is today's. Now, what did you calculate to be her, the amount of her household work?
Mrs. Potter's household work, projected future household work,
Future household work. Can you better explain that to me?
these numbers, my methodology is based on future earnings, future fringe benefits, future household work, and future consumption.
I'm talking about her household work, not everything else.
Okay, the household work I compiled from data using the UHCL.
What was the amount that you calculated for her household work in terms of per hour?
Per hour, $41.
$41. Isn't that the same amount that she earns at Technosoft
Yeah.
per hour?
Yeah.
Now, at work, does she use her skills?
Yeah.
Does she use her skills to work at home?
Had she hired?
I said, do you want me to restate my question?
Please.
I'm saying, does she use her skills, like training at Technosoft, to use at household for her household work?
Yes, she did.
Does she does?
She did.
What did it include?
She did all of the paperwork. She produced the financial statements monthly and annually for the family household.
Okay. Now, does she do laundry and clean the dishes and cook?
No, she did not do the manual labor.
She didn't do that?
No.
What kind of, well, she does do manual labor.
She did not do manual household chores. Her husband, Jeff, was responsible for that.
Okay. Now, can I have you turn to Exhibit 48?
Yes, ma'am.
Do you recognize that exhibit?
Yes.
Without giving any details, what is it?
Exhibit 48 is a memorandum that was sent to me that I, yes, Exhibit 48 is a memorandum that I sent to Dr. Dyer, my research assistant.
You sent that to Steve Dyer?
I'm sorry, I received from Dr. Dyer.
Okay. Your Honor, maybe publish Exhibit 48 for the jury?
48 is not admitted.
Okay. Let's see. So it's a email from, or a memorandum from Steve Dyer. Am I correct?
Yes.
Okay, now, do you do your own research?
Yes.
You do your own research? Now, what is Steve Dyer's job?
Steve Dyer is a research assistant.
He's a research assistant, so he helps you do your research.
Yes.
Okay, so let me turn to Exhibit 47. Oh, wait. No. 45. What is it?
It is a sample of my curriculum vitae.
Can you repeat that?
It is a sample of my curriculum vitae or resume.
A resume. Okay. And you've published several articles?
Yes, I have.
Okay, now can you name your articles?
Yes.
What are they?
Just reading from here, my articles are the effects of September 11th on microeconomics. Is your loss worth anything? Can your economic system survive a terrorist attack? And valuing services and potential retirement.
Okay, thank you. Now, going to 46, that is your report. Am I right?
Exhibit 46.
46, yes. Or 44, sorry.
Can you repeat that?
44, Exhibit 44. Okay, can you read your first sentence on there? Can you read sentence 1 of the opening of your opinion? Section of your opinion?
Exhibit 44.
44. What is that?
It's a copy of my report that I compiled.
Can you turn to page 39 and read the first sentence in your opinion?
Thank you. I, Roberta Glenn, understanding matter involves Jeffrey C. Potter, the administrator.
Ma'am, under the section of opinion.
Based upon my continuing review and analysis of the Potter versus Schreckle case file, supplemented with my own research of relevant economic and demographic information, I have developed the following opinion regarding economic.
I said the first sentence, not the second. Thank you. Now, do you always count your research assistants research as yours?
No.
You don't?
No.
Can you read that first sentence again in your opinion?
Based upon my continuing review and analysis of the Potter versus Schreckle case file, supplemented with my own research of relevant economic and demographic information, I have developed the following.
Okay, thank you. Now, 48 was a memorandum to Steve Dyer, who is your research assistant. Am I right? Okay, thank you, ma'am. No further questions for this witness.
Any redirect?
No, Your Honor.
Okay. Dr. Glenn, thank you for your testimony. Is this witness excused by the plaintiff?
Yes, Your Honor.
Is this witness excused by defense?
Yes, ma'am.
Okay, Dr. Glenn, thank you very much. You may go on about your normal routine. You are excused. Call your next witness. This one. Sure.
Can I sit there?
Counselor for the plaintiff may call your next witness.
Your Honor, plaintiff calls Marilyn Kelly to the stand.
Okay, Marilyn Kelly, has this witness been sworn?
No, Your Honor, she hasn't.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay, you may have a seat, please. Proceed.
Yep. Could you please state your name to the jury, please?
It's Marilyn J. Kelly.
And where do you live, Miss Kelly?
I live in Nita City, Nita.
And what is your connection to this case?
I was at the scene of the incident when the defendant hit Mrs. Potter.
Could I direct your attention to Exhibit 10 in the trial notebook, please?
Okay.
And without describing anything, what is it?
It is a picture of the intersection of Madison Kirby.
Is it a fair and accurate photo of the intersection that you were at the day of the incident?
Yes, it is.
Your Honor, at this time, plaintiff offers Exhibit 10 into evidence.
Has opposing counsel had an opportunity to view this exhibit?
Yes.
Yes?
Yes, Your
Okay, is there any objection?
No objection.
Admitted.
Your Honor, plaintiff requests to project Exhibit 10 to the overhead for the jury.
The exhibit that was admitted,
Yes.
that's been tendered and viewed by the defense, correct?
Yes, ma'am.
Okay, granted.
Is this the intersection that the incident took place?
Yes, it is.
And can you describe, according to the photo, what you see in the photo?
There are people walking in the crosswalk.
And according to the diagram in Exhibit 10, can you point to where you see these pedestrians in the crosswalk?
The pedestrians are in this crosswalk right here.
And what else what color is the traffic light in the photo of Exhibit 10?
The traffic light is green.
And can you point to where on the diagram the traffic light would be located on the diagram?
Traffic light's right here.
Okay. With this traffic light green, the pedestrians are in the crosswalk, correct?
Yes, they are.
Now, let's move back to the incident. Could you tell us what you were doing before you arrived to the scene of the incident?
I was on my way to an appointment that I had with my firm's accountant. It was at 3:30.
And while you were on your way to this appointment, what were the traffic conditions that day?
There was heavy traffic. What normally takes me a 10-minute drive, that day took me 25 minutes.
And what did you see when you arrived to this intersection?
As I was pulling to stop at the intersection, I witnessed a boy run through the crosswalk and almost get hit by another vehicle.
Now, when you arrived to this intersection to see that, can you point to where you were located when you came to a stop on the diagram?
My car was located right here. I was the first car in line.
Okay. And where was this boy that you saw almost get hit? Where was he located?
He was running through the crosswalk in this general area.
And the car that almost hit him, can you point to the direction that car came from?
The car was coming from here. He was turning from Kirby onto Navis.
Okay. Now, after seeing all this, what happened next?
Young man was pulled to the corner and was talking to the crossing guard.
Okay. And after seeing the crossing guard talk to the boy, what did you see next?
I turned to my left. I saw a woman step off the curb. She took about 2 or 3 steps into the crosswalk.
And according to the photo, can you point to where she took these couple steps?
She stepped off this curb and took steps about right here.
And after you saw this, what did you do next? What did you see next?
I looked up to my right to see if it was my time to go. And during that time, I heard a truck hit the woman in the crosswalk.
And can you point, according to the diagram, where you saw or where you heard the truck hit the woman?
The truck hit the woman about right here. It was about even with the front of my vehicle.
Okay. And after you heard the truck hit the woman, what did you see next?
The woman was laid out on top of the truck, her arms sprawled across the hood.
And after you saw this, what happened next? So you saw the woman with her arms spread out on the front of the truck. What happened after you saw this?
The driver then hit the brakes and her head smashed into the pavement.
And was the driver stopped at that time when the lady's head hit the pavement?
No, he didn't come to a complete stop until he was completely on top of the woman.
And what was your reaction to that?
I remember thinking to myself that I please don't run over her again.
So after seeing all this go on, what happened next?
The driver got out of the truck, went around to the front, and the man ran from the car wash to help.
And did you recognize this driver at all?
It was very bright that day, but I thought he might be Charles Schrackle.
And you say Charles Schrackle. Who exactly is him? Who exactly is he? How do you know him?
I work for a local construction company, Build It, and he is a competitor company. So I know him from building association meetings, and also my company took over one of his jobs in the past because the school district was not satisfied with his completion.
And what was your impression of Mr. Schrackle then from knowing him through business encounters?
He seems arrogant, hurried. He seems to be climbing to the top, which is kind of funny since I don't think his business is doing very well.
Okay, so now after all this took place, what happened next?
Well, like I
Now, was this the last you heard of the incident?
No, it's not. I also read about it in the Needham City newspaper.
And what was your reaction to this story in the Needham City newspaper?
They got it all wrong.
What do you mean they got it all wrong?
It said that the woman was running outside in a crosswalk.
And what did you do about this wrong statement?
I called the police to give my account of what happened that day.
And did your decision to make this phone call had it have anything to do with Mr. Strackle?
No, it didn't.
And would you have anything to gain if it did?
No, I don't.
So after you called the police to make your report, what did you state in your report?
I stated that the woman was walking within the crosswalk.
Your Honor, plaintiff passes the witness.
Any cross?
Yes, Your Honor.
Okay.
Marilyn, can you turn to Exhibit 34? Now, can you read what are your feelings towards Mr. Strackle? Well, what are your feelings towards Mr. Strackle? It's a question.
That he's arrogant.
Is arrogant?
Objection. She didn't lay a foundation for the deposition.
Overruled.
Okay. So what are your feelings towards Mr. Strackle?
That he's arrogant.
That he's arrogant. Do you like him much?
I don't know him well enough.
But you do know about him, don't you?
His demeanor.
His demeanor? Well, where does he work?
He works for a community construction company.
And that's a competitor to you, isn't it?
It is.
Okay. And now, Marilyn, so you said you saw or you heard the accident first?
I heard the accident first.
What were you looking at the intersection?
I was looking at my light.
You were looking at the light. So how can you see? Did you see the accident?
No, I already stated I did not see the accident take place. I heard the accident take place.
You heard the accident, but you did see what happened to Mrs. Potter, didn't you?
That would be correct.
So what happened?
That the truck hit Mrs. Potter when she was within the crosswalk.
So you were looking at the light and you saw that Mr. Strackle carried her on his truck.
I heard the impact and then I saw it.
Did you turn to look at the accident?
Yes, I did.
So you were looking at your light and you had time to look at the accident.
I looked at the light and then I looked at the accident.
So you heard the thud. That's what you said, right? And then you were looking at your light. So you were looking at your light and then you heard the thud. And then you looked at the accident.
Yes.
Okay. And let's see. Can you read in your deposition, can you read line 20 through 21?
I then glanced back up at the light, and at that time I heard the thud. I looked up and saw the woman flying through the air and then land with her arms outstretched on the front of the truck.
It doesn't say that you turned to look. Where did the accident happen?
It happened to my left.
To your left. So you were looking at your light, and then you also said that you looked up and saw the woman flying through the air. Am I right?
Yes, the accident happened to my left, so I would have had to have looked.
But you don't say that you turn your head. It just says that you look up. The accident didn't happen in front of you, did it?
I know, but it doesn't say I was breathing there either. But
Well, can you point at where you were on this diagram, please?
okay, I was right here, and my car was right there.
So you were looking up at the light, and you said that you saw Mrs. Potter in the crosswalk.
Correct.
Now, can you point on the picture where you were?
In the picture, I would be on the other side of his vehicle.
Could you see Mrs. Potter if you're looking up at the light on the crosswalk?
Yeah, I could see him.
Is there another car in the picture?
This is not a photograph of where my car was. This is a photograph.
Did you say that it was packed that day at that intersection? That it was a busy day, there were a lot of cars on the street? Am I right?
I said there was heavy traffic on the way to my
So there is a possibility.
Okay,
Sorry.
repeat your question, please.
So is there a possibility that Mrs. Potter was in the crosswalk? Or is there a possibility that you had another car in front of you? Or on the side of you?
I don't know.
You don't know? Well, just by looking at the picture, there's a possibility that there could be another car there. Isn't there?
Possible.
All right. Now, Marilyn, are you positive that you saw Mrs. Potter at the crosswalk?
Absolutely positive.
With the possibility that there's a car next to you?
I said it was possible. I didn't
It was,
say there was a car next to me.
but it's possible with all that traffic. Your Honor, the defense has the witness.
Any redirect?
Yes, ma'am.
Go
Yes,
ahead.
Your Honor.
Okay.
Now, when you saw Mrs. Potter take a couple steps in the intersection, what was she wearing?
She had dark hair, she was wearing a dark jacket that had a little bit of color in it, and she was also wearing a dark skirt.
So you remember exactly what she was wearing.
Yes, I do.
And you didn't see Mrs. Potter get hit by the truck because you were looking in front of you.
Correct.
You were looking at the light in front of you because that's what responsible drivers do. They look at the road in front of them because that's what drivers do, correct?
Yes, ma'am.
No further questions, Your Honor.
Any recross?
Yes, Your Honor.
Okay.
So if you're being a cautious driver, Marilyn, how is it possible that you were looking where the pedestrians are on the crosswalk? You're being a cautious driver, so you were looking at the crosswalk? You were looking at people? You were looking straight at Mrs. Potter?
Well, I mean, a driver doesn't normally look forward, it also looks around and other things as well.
But you said in your deposition you were looking up at the light.
Right, to see if it was my right of way to go.
Well, you're at an intersection, so you're at your lane. You go straight, don't you?
Yeah, when the light turns green.
Well, yeah, but you were looking at the light. So you were looking straight at Mrs. Potter?
When I was looking at the light, I've already established that I was not looking at Mrs. Potter.
Okay, so you weren't looking at her.
When I was looking at the light, no.
Okay. Your Honor.
Redirect?
No, Your Honor.
Okay. May this witness be excused by plaintiff?
Yes, Your Honor.
By defense?
Yes.
Okay. You may resume your normal routine, Miss Kelly. Yes, ma'am. Call your next witness.
May I check the mic again?
Yes, sir.
May I have a second here, I'm gonna change the battery.
Yes, sir. On your way. Call your next witness.
Your Honor, we call Charles T. Schrackle to the stand.
Has the witness been sworn?
No, Your Honor.
Okay, Mr. Schrackle? Okay, do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead and approach and have a seat, please, sir. Mr. Schrackle, please remove your hat in the courtroom. Proceed.
Your Honor, we call Mr. Schrackle as a hostile witness. Now proceed.
Okay, any response?
No, Your Honor.
Okay, you may consider him a hostile witness,
Thank you.
which means
May I
that
proceed?
you may lead the
Yes.
witness. Okay,
Yes, Your Honor.
ask leading questions, okay?
Yes. Could you introduce yourself to the jury by stating your name?
My name is Charles Schrackle.
And you reside in Nita City, correct?
Yes, that's correct.
And you're here today because you struck Catherine Potter while you were driving your company truck. Isn't that true?
Yes.
And you drive a 2001 Toyota Tacoma truck. Isn't that true?
Yes, that's correct.
And you have a Superman logo on the truck that identifies your truck. Isn't that true?
Yeah, that's true.
Could you turn to Exhibit 6 in your exhibit book? Do you recognize the exhibit?
Yes, I do.
What is it?
It's a picture of my truck and myself.
Is it a fair and accurate picture of you and your truck?
It is.
Your Honor, plaintiff offers Exhibit 6 into evidence.
Any objection? Admitted?
Your Honor, may I project the exhibit?
You may.
6, thank you. And when you struck Mrs. Potter with this truck, you seriously injured her,
Yes, she was injured.
and she died as a result of those injuries?
She did.
And you're a self-employed excavating contractor, correct?
That is correct.
And November 30th, you had 12 full-time employees, isn't that right?
Yes, that's correct.
And on November 30th, 2010, you were involved in 2 excavation projects, isn't that true?
Yes.
And the Greenbrier Manor project was giving you some problems, right?
Oh, yeah, we had run into some rock.
Okay. And isn't it true that you were past due for completion on a portion of the Greenbrier job? Isn't that true?
Oh, yes.
Okay. And Clark Poe was the general contractor of this job, correct?
Yes, he was.
And the day before the incident, you received an email from Mr. Poe, didn't you?
I did.
And there were delays on the project, isn't that true?
Yes, as I said, we had run into some rock on the excavation, and it was going to take a little longer than we initially anticipated.
Okay. And Mr. Poe found the delays unacceptable, isn't that correct?
Yeah, I don't know how he thinks.
Okay. Due to the delays, the developer would fire your company and hire somebody else, isn't that true?
Objection, Your Honor. Speculation.
Any response?
No, Your Honor.
Okay. Sustain.
If you lost the job, you would endanger the jobs of your employees, correct?
I don't think so, no. I could get other jobs.
Okay. Mr. Poe made it clear that you needed to finish the job immediately. Isn't that true?
No, he'd given me an extension. In fact, we finished the job the day after the accident.
Okay. But he summoned you to the job site on November 30th, the day of the incident, correct?
Yes, that's correct.
So you can give him details about the problems, right?
Yeah, that's correct.
And he needs you to give him a firm commitment on a conclusion date. Isn't that true?
Yeah, that's correct.
But he made it clear to be there on time. Isn't that true?
He did, but we discussed a different appointment time.
Okay. Could you turn to Exhibit 23 in your exhibit book? Do you recognize it?
I do recognize it.
Without stating the content, what is it?
It is it's a map of the intersection.
No, Exhibit 23.
Exhibit 20. Oh, sorry. I thought you said 3. Yes, it's the email I received from Clark Poe.
Your Honor, plaintiff offers Exhibit 23 into evidence.
Any objection?
Objection, Your Honor. Hearsay.
Your Honor, we're entering. Oh.
Go ahead.
Your Honor, we're entering it as an admission by party opponent.
Objection sustained.
Okay. So you emailed him right back after you received that email.
Yes, I emailed him back.
And then you told him that you weren't going to be late, didn't you?
Yeah, I did.
And that you were going to be there on time?
Yes.
Could you turn to Exhibit 24 in your exhibit book? Sorry, 23 into your exhibit book? 24 into your exhibit book, sorry. Do you recognize it?
I do.
Without describing the content, what is it?
It's a email I sent to Clark Poe.
As a response, isn't that correct?
Yes, that's correct.
Your Honor, plaintiff offers Exhibit 24 into evidence.
Any objection? Admitted?
Your Honor, I'm going to enter it in as a business record. Oh, I'm sorry. Oh, no objections. Oh, there was an objection? Oh, my gosh. Sorry.
Continue.
Could I display the exhibit?
Yes, you may.
Now the last line says that I assure you I won't be late. Isn't that true?
That is correct. That's what it says.
So when you were going to the job site on November 30th, that's what was on your mind, correct?
No, I had actually made a phone call to Poe on my way to the site.
Because you didn't want to be late. Isn't that true?
Yes, and he gave me an extension.
Okay. So let me take you to November 30th, 2010, the day of the incident. And you started your work day at the John and Holiday Park. Isn't that true?
No, I started it at the office.
Okay. But then after that, you went to the Holiday.
Correct.
John and Holiday Park. Okay. And you left that site at 2:30 p.m.?
Yeah, around 2:30.
And then you went to the Nita Supply Store near downtown?
I did.
And then you ordered supplies?
Yes, I had to pick up materials for our jobs.
And you had a conversation with another contractor about bad business?
Correct.
And you were distracted?
I wasn't distracted.
Okay. But you realized that you were late for the meeting. Isn't that true?
Yeah, I wasn't late yet, no.
You were running late for the meeting.
Yeah, it was
Isn't
about
that
20
true?
minutes from the meeting, yes.
Okay. Because you had the conversation and then you realized it. Isn't that
Yeah,
correct?
correct.
Okay. So you left the builder supply store at about 3:10 p.m. to go to the job site, correct?
Yes.
And as you were heading down towards Mattis Avenue, where the incident took place, you picked up your cell phone. Isn't that true?
Yes, I made a phone call to Clark Poe.
Okay. And it took about 5 to 10 minutes from the supply store to get to the intersection.
Objection, Your Honor. How is this relevant to the accident?
Overruled.
And you were heading, so it took you 5 to 10 minutes from the builder supply store to get to the intersection of Kirby and Mattis. Isn't that right?
Yeah, it was around that time.
Okay.
It'd probably taken, about closer to 20 minutes, actually.
Okay. Do you remember on December 11th, 2011, that you spoke in your deposition, that you were sworn?
Yes.
Okay, in your deposition. Now, you stated in your deposition that it was about 5 to 10 minutes from the supply store to the intersection. Is that correct?
It was busy at the time. School had just gotten out and traffic was heavy.
Okay. So you stated previously that you were on your cell phone, correct? And this was the time, correct?
Yes.
And this is the time that you picked up your cell phone to call Mr. Poe?
Yes, after I left the supply store.
Okay, to tell him that you were late?
Yes.
Okay. And you were still on the cell phone with Mr. Poe when you arrived at Mattis, correct?
I don't remember.
So you don't know, because you were so distracted, you don't know if you were on the phone or not?
No,
Is that
I don't
true?
remember.
Okay, turn to Exhibit 18 in your exhibit book. And what is that?
That's a picture and map of the intersection.
Is that a fair and accurate depiction of the intersection at the time of the incident?
Yeah, it's a picture of the intersection, but the cars are different and some of the situations are different in the picture.
Your Honor, Plaintiff offers Exhibit 18 into evidence.
Has this exhibit been provided to the defense?
Yes, it has been agreed to.
Okay, the one that you're offering?
Yes, Your Honor.
All right, any objection?
No, Your Honor, as long as the exhibit 18 and notebook that Mr. Schrackle has in front of him.
Okay, with no alterations?
Correct.
Is that understood?
Okay. Your Honor, could we display the exhibit?
Okay, there being no objections, this exhibit was previously agreed, at least in the form that it was provided before trial to defense counsel
Your
for
Honor.
inspection. That's what is agreed upon.
Your Honor, could we approach the bench?
Yes, you may.
All I was going to say was no one provided me some executives. There was a CD in that Benson told us we could use it. And we're not changing the exhibits, we're just juxtaposing them like they are in the book.
But have they ever seen what you prepared?
No, ma'am.
Yes, we did show it to you.
Okay, I'm ready to make a ruling. All right.
Okay, I will admit, I'm sorry, what exhibit? Is this Exhibit 18? And the black and white form that it was provided to, or in any form that it has been provided in the exact form to defense counsel, I will admit it. In any other form, unless they see it first and have an opportunity to object, it is not admitted.
Your Honor, may I display the exhibit?
If it's in the exact same form, yes, you
Yes.
may.
May
Then, wait, sorry, then you're offering that exhibit.
Yes,
Exhibit
I-
number 18, and that
sorry.
exhibit being agreed to in the form that has been viewed by defense counsel, they've agreed to that, it's admitted.
Can I approach?
Yes, ma'am. And you need to mark it. Exhibit
it is
18,
exhibit
okay, great. And you need to identify it for the court reporter.
So here on Exhibit 18, you are coming in this direction from the supply store, isn't that correct?
That is correct.
Now, can you turn to Exhibit 16 in your exhibit book? And what is that?
That would be the lane that I would have been in when I approached the intersection.
Okay, is it a fair and accurate depiction of the intersection at the time of the incident?
It is.
Your Honor, plaintiff offers Exhibit 16 into evidence.
Okay, Exhibit 16, is it in the form that has been previously agreed to by the defense?
Yes, Your Honor, it was in our book.
Okay, all right, so the same ruling applies if the same objection is made on 16. Okay, all right, admitted.
Your Honor, may I approach?
Yes, ma'am.
Okay. Now, this, when you approach the intersection, coming right here, you would have been in this lane right here. Isn't it true?
Objection, Your Honor. The counsel is testifying for my witness. He can point out where he was at the time or the location he was at.
Overruled.
Your Honor, Mr. Schrackle, you were in this lane right here. Isn't that true?
Yes, that's true.
And you would be where this car is right now. Isn't that true?
Yes, that's true.
And you would be looking at this light right in front of you. Isn't that correct?
Yes.
Your Honor, may we zoom in to the picture?
Yes.
Best as we can. Thank you. So again, this is the light that you were looking at. Isn't that correct?
Yes, ma'am. That's the light I was looking at.
And right on top of this light, there is a sign, isn't there?
Yeah, there's a sign above it.
And it's a left turn signal sign, isn't it?
I don't know.
It's a protected light, isn't it?
I don't know.
And this is a green arrow, isn't it?
I don't know. I can't tell from the photograph.
Okay. Your Honor, May I display Exhibit 16 zoomed out?
Yes.
Thank you. And could I approach the display?
Yes, ma'am.
Thank you. Now, when you approach the intersection, when you were coming to the intersection, you didn't stop, did you?
No, the light was green.
Okay, but when you were approaching the intersection, you didn't stop, you just slowed down, didn't you?
Yes, that's correct.
And the reason you slowed down was because before turning, you waited for another car to pass by. Isn't that true?
Yeah.
Okay, and the car passed from this direction. Isn't that true?
Can you do that again?
Passed from this direction.
Yes,
Isn't
that's
that true?
correct.
So they had the green light. Isn't that true?
I had a green light as well, yes.
Okay. Well, if they had a green light and they went and you had a protected light, isn't it true that your light was red?
No.
Okay. Let's go back to Exhibit 18. Your Honor, may I display it?
18 is admitted, yes.
Is that 18? Okay. So as you were turning onto Mattis, you turned just like these cars are turning right here. Isn't that true? You were turning like that?
Yes, I was
Isn't that
making a
true?
left turn.
Okay. And there's a crosswalk right there. Isn't that true? Which would be right here.
That is correct.
Isn't that true? And that's where you hit Mrs. Potter, correct?
No.
Okay. So as you made the left turn, okay, there was a crossing guard right here in this corner. Isn't that correct?
Yes.
And right across from the cross guard on the other side, in the opposite direction, on the opposite side, were children. Isn't that true?
Yes, there's 3 school children.
Okay. So as you were making your turn, you were looking at the cross guard right here. Isn't that correct?
No, that's not correct.
Okay. As you were making your turn, you looked to your left and you saw the cross guard right here. Isn't that true?
No, that's not true. I was actually looking at the school children. I didn't want them to run out into the street.
Okay. In your deposition, you first stated that you looked to the left, to the cross guard.
I
You
did.
saw
I did.
some
I saw
children.
the crossing guard as well.
Okay. So then you looked to the other side, to the right, to the children, correct? As you were turning, you were looking at the children, correct?
Yeah, I normally scan the whole crosswalk in front of me
Because
when
it's
I make the
important
turn.
to look
It
out.
is.
Yeah, look out for children, isn't it? So while you were turning, your eyes were focused right there when you made the turn. Isn't that true?
Yes, I had my eyes on the children. I didn't
Okay.
want them to run out.
So you didn't even know how fast you were going because you were looking at the children. Isn't that correct?
Well, I don't look at my speedometer while I drive. I mean,
Exactly.
when
The
I'm making my
speedometer's
turn
in the front of you, correct?
and down.
Okay. And so as you were looking at the children, that was the very moment that you hit Mrs. Potter. Isn't that true?
No, I'd actually gone a couple seconds past the children before I felt the impact.
Yeah, but you stated that you were looking. You were
Yes, I was
distracted.
looking at the children, yes.
Okay, okay. So she was in the crosswalk, correct?
That's not correct, no.
Okay. So you didn't even know you hit Miss Potter because your eyes were on the children. Isn't that true?
I did not see her until after the accident.
Okay.
no.
So you had no time. You had no time to avoid striking her. Isn't that correct?
No time at all, no.
Because you were not looking in front of you. Isn't that true?
No, that's not true.
Okay. But you were looking at the children as you were turning. You just stated. Isn't that correct?
Yes, I saw.
Okay. So you were not looking in front of you. Isn't that true? And
I mean, no. I mean, I don't know.
okay. And because you weren't keeping proper lookout, you didn't sound your horn, did you?
I did not sound my horn, no.
You didn't even apply your brakes before you hit Mrs. Potter. Isn't that true?
I did not apply my brakes until afterwards.
Okay. It wasn't until after you felt the impact that you applied your brakes.
Correct.
Isn't that true? Okay. And all of that was because you were distracted, right?
No.
You were thinking about your meeting?
No.
You didn't want to be late, did you?
I knew I wasn't going to be late.
So you jumped out of your truck, and the first time you saw Mrs. Potter was when she was lying under your truck. Isn't that true?
Yes, that's correct.
And when you saw her, she seemed to be conscious. Isn't that true?
Yes, she was.
What did you ask Mrs. Potter as she laid on the ground?
I just asked where she came from.
And she didn't reply, did she?
She did not.
Then Officer Michelle Young arrived. Isn't that true?
Yes, Officer Young.
And that's when she asked you to move your truck back. Isn't that correct?
Yes.
And you moved your truck off of Mrs. Potter. Isn't that true?
Yes.
And you got a first aid kit out of your truck. And Officer Young applied a bandage on Mrs. Potter's head. Isn't that true?
Yes, that's correct.
And you waited for the ambulance.
Yes, that's true.
And you immediately called Mr. Poe about the Greenbrier project, correct?
I did, yes. I let him know.
Yeah, and because you were still thinking about your meeting, correct?
Yeah.
So you told him what happened.
Yes, I let Mr. Poe know what happened.
But you didn't lose the job, did you?
No, I met with him the next day.
But there's a reduction in the pay for the job. Wasn't that true?
Yes, that's correct.
You weren't happy about that, were you?
I mean, it wasn't insignificant.
But you weren't happy about that, were you?
I don't know. It was insignificant compared to what had
Your
happened.
deposition stated you weren't happy about the reduction in pay.
I mean, I wasn't happy about losing the money, no.
Okay. Your Honor, we passed the witness.
Any cross?
Your Honor, we do not cross the witness. However, we do reserve the right to recall on direct.
Okay. All right. You may step down, Mr. Shackle. Call your next witness.
Your Honor, plaintiff calls Michelle Young to the stand.
Has Ms. Young been sworn?
No, Your Honor.
Okay. Raise your right hand, please. Do you swear to tell the truth, nothing but the truth, the whole truth?
I do.
Okay. Have a seat, please.
Your Honor, may I proceed?
Yes, you may. Well, just a moment.
Can you please tell the jury who you are?
Officer Michelle Young, and I work for Nita City Police Department.
And can you tell us your connection to this case?
I was dispatched to the scene of an incident on November 30th, 2010, which involved a pedestrian being struck by a motor vehicle.
And what are your primary duties as a patrol officer?
Primarily, I do general patrol duty.
And as a police officer, what are the duties of all drivers on the road?
All drivers must keep a proper lookout in front of them.
And what must drivers do if they are suddenly and unexpectedly approached by a pedestrian?
All drivers must give a proper warning and then exercise due care to avoid a collision.
Now, let me take you to the day of the incident. What did you see when you arrived?
I saw a woman lying on the pavement under a truck.
And what did you do?
I asked the driver to pull the truck back so I could render aid to the woman.
And when he did that, what was the condition of the woman?
She seemed to be alive, but she was in a lot of pain.
And what do you mean she appeared to be in a lot of pain?
She was moaning and she had a grimace on her face.
Was she conscious?
Yes, she opened her eyes several times.
And were you able to communicate with her?
Yes, I heard her say the name that sounded like Jeff 3 or 4 times.
And after you saw all of this, what did you do?
I waited with the woman, or Catherine Potter, until the ambulance could get there to take her to the hospital.
And can I direct your attention to Exhibit 4 in the trial notebook?
Okay.
And what is it?
It's a photo of the woman I saw on the pavement lying under the truck.
And, Your Honor, plaintiff offers Exhibit 4 into evidence.
Any objection?
Inflammatory, Your Honor.
Could you be specific?
The jury doesn't need to see a picture of the woman on the ground with these injuries. She can explain them.
Any response?
Let me properly lay the evidence further then. Okay. If that's, what is the description of the woman in the Exhibit 4?
She has dark hair. She's wearing a dark jacket with some color on it with a dark skirt.
Okay, moving along. That's enough said.
Okay.
Can I direct your attention to Exhibit 12 in the trial notebook, please?
Yes.
And without explaining it.
It's a picture of the intersection.
And is that a fair and accurate depiction of the intersection that you took on the day of the accident, the day after the accident?
It is.
Your Honor, at this time I offer Exhibit 12 into evidence.
This exhibit also was previously agreed as it was provided to defense. Does defense raise the same objection to any other exhibit offered as number 12?
We do, Your Honor.
Okay, then the same ruling will apply.
Yes,
And
ma'am.
under that circumstance, it is admitted.
Yes, ma'am. Can I project it on the overhead to the jury, please?
Yes, ma'am.
Now, according to the photo of Exhibit 12, can you tell us what the traffic light indicates?
It indicates a red left turn signal.
And does that indicate that it's a yield left turn signal?
No.
No further questions, Your Honor.
Any cross?
Yes, Your Honor.
Okay, continue.
Objection, Your Honor. Cross time is out of time. The defense cross time is out of time. They extended their 20-minute period. That was directed for our problem.
Okay. All right. You may step down. Officer Young, call your next witness.
Plaintiff rests their case.
Okay.
Your Honor, plaintiff rests their case.
The plaintiff is rest. Defense, do you have a witness?
Yes, Your Honor. The defense calls our first witness, Alice Mallory.
Okay. Oh, break. Sorry. All right. 15-minute break at this time. Jury, wait. Let the jury go first, please, with the bailiff. You're instructed to be back in your seats, jurors, in 15 minutes by the clock on the wall.
What do you mean?
Do that. Don't be shy.
Oh, well.
Well, I can't even
I just got
imagine. But, yeah.
Left turn yield.
But you both, they learn that way, and so they all.
I'll get it throughout the
We've all done it. My grandmother, when I started law school, she said, just one rule, never ask to have anything read back. And in 25 years, I've probably asked once, maybe twice. But her voice is in my head.
Should I grab any of this?
I've asked your Kentucky bride to get Edie if we go late. And she has Susan has graciously agreed to be my backup plan if we go late to retrieve Evie from tents. I hope that's okay.
That book small? We charge batteries in this one, so we don't want that one. It's always the case, isn't it?
It is.
this is, these are very strong students, and that's been my experience, the strong come forward for this.
We have a new magnet school in elementary, just started up at White Elementary, and it's a STEM program in essence, and their motto is something like, I may have told you this already, but you have to fail to learn. And I just think it's the coolest thing, and really, I mean, that is, of course, that's what science is all about, but that's what life is all about. If you're not willing, if you're not a risk taker, you can't learn anything. That's right, but people are always so, and I'm that way, so apprehensive about failing and how they look. They don't want to be a failure, but yeah, if you put yourself out there, you learn. It is a great thing. Yeah, you learn all sorts of stuff.
Well, y'all haven't no one's asked you to read anything back yet.
Aren't you glad you chose this path? Usually it's the jurors who ask. Yeah. Okay, is the plaintiff ready to continue? Is the defense ready?
Yes, Your Honor.
Bailiff, bring in the jury, please. Everyone will rise for the jury. Please be seated. Okay, is the defense ready to call the first witness? Go ahead, please.
Your Honor, the defense calls Alice Mallory.
Has this witness been sworn?
No, Your Honor, she has not.
Okay. Miss Mallory, raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth? I do. Okay, have a seat, please, ma'am. And adjust the microphone as needed.
May I proceed with direct?
Yes.
Thank you. Okay. Can you please state your name for the court?
Alice Mallory.
And Alice, do you have any family?
I do. I have a husband and 2 teenagers.
And what do you do for work?
I was a part-time crossing guard for the school district.
How long were you crossing guard for?
2 years. I did the morning and the afternoon.
Okay. Before I get into the depth of this case, do you know any of the parties involved?
No, I do not.
Okay, thank you, Alice. Now, Alice, can you tell me how you are connected with this case?
I was working the corner where the accident occurred.
Okay. Let me take you back to the day of the accident, November 30th, 2010, and call your attention to exhibit number 3. Your Honor, may we publish exhibit number 3 to the jury?
Exhibit 3 is not admitted.
We both agreed on that.
It's not admitted.
Okay. Alice, can you please, do you recognize exhibit number 3?
Yes.
What do you recognize about it?
It's a depiction of the intersection that I was working at.
Is this an accurate depiction of the intersection?
Yes.
Your Honor, the defense offers exhibit 3 into evidence.
Okay, exhibit 3 I show has been agreed by both parties. There being no objection from the plaintiff.
No objection.
It's admitted.
Your Honor, can we publish exhibit 3 to the jury?
Yes, sir.
Thank you. Okay, Alice, could you please point on this map above the location you were at on the day of the accident?
Sure. I was here, but there was a little boy who had run across into the street, and I was afraid he was going to get hit. So I walked over to the next intersection and reprimanded the boy.
Okay, and about what time would this have been?
3:25 in the afternoon.
Okay, so Alice, at 3:25, you started on the intersection
Right
or the
there.
corner in front of Marshall Tires.
Mm-hmm.
You crossed the street to reprimand a little boy who ran out in traffic.
Correct.
And you ended up in front of the White Castle?
Correct.
Okay, thank you, Alice. Now let me call your attention to exhibit number 13. Do you recognize this exhibit?
Yes, that's my viewpoint of the intersection.
Okay. Minus the lighting and the cars, is this an accurate depiction of the intersection as you saw it?
Yes.
All right, thank you. Your Honor, can we publish exhibit number 13 to the jury?
Exhibit 13 is not admitted by my record.
Your Honor, the defense offers exhibit 13 as evidence.
Exhibit 13 being an exhibit that was previously agreed to, there being no objection from the plaintiff,
No objection.
it's admitted.
Can we publish exhibit 13 to the jury?
Yes, you may.
Okay. Alice, you stated this was your viewpoint?
Correct.
Okay. And at this time, you were talking to a little boy, is that correct?
That's correct.
Okay. Now, Alice, what did you observe while you were talking to this little boy?
I noticed a dark-haired woman begin to walk across the street.
Okay. Can you please point to the picture above where you saw this woman walk out?
Sure. She was here, and she started walking in the crosswalk.
Okay. Did she take any actions while she was walking the crosswalk?
Yes. When she was in the middle of the crosswalk, she actually got out of the crosswalk and started walking down the center strip.
Mm-hmm. Did you see the accident occur?
No, I did not.
How did you know that there had been an accident?
I heard it.
Okay. How long was the hit when you saw her out of the crosswalk?
It was a few seconds.
Almost simultaneously?
Almost.
Okay. Thank you. Let me call your attention to exhibit number 17. Do you recognize this exhibit?
Yes, that's the intersection I was at.
Is this an accurate depiction of that intersection, minus some of the cars or the lighting?
Yes.
Thank you. Your Honor, defense offers exhibit 17 into evidence.
Exhibit 17 has previously been agreed to. There being no objection from the plaintiff,
No objection, Your Honor.
Exhibit 17 is admitted.
Your Honor, can we publish exhibit 17 to the jury?
Yes, you may.
Thank you. Okay, Alice, on the picture above, can you please point out where you were located again?
Sure. I was here.
Okay, and once again, retrace the steps of the pedestrian.
She was here, here. And then she entered the crosswalk there, and then she started walking down that center strip.
Okay, and she was out of the crosswalk at the time she was hit, correct?
Correct. She was not in the crosswalk.
All right, thank you, Alice. Now, after being a witness to this accident, did this affect you at all?
I was pretty upset. My worst fear was that a child would be hit while I was on duty.
Okay. Alice, do you still work as a crossing guard?
I do not. I retired, or I resigned 3 weeks after the accident.
Was this the main factor for your resignation?
No, the main factor was I was worried about the children, and the accident did upset me, but also my eyesight was starting to deteriorate.
Alice, what's wrong with your eyesight?
I have open-angle glaucoma.
And did you have this open-angle glaucoma at the time of the accident?
It was undiagnosed at the time of the accident.
And so was your vision affected at the time of the accident?
No, it actually doesn't affect my central vision. It was just starting to affect my peripheral vision.
Okay. Let me call your attention back to exhibit number 13. Your Honor, can we show exhibit number 13 again to the jury?
Yes, sir.
Thank you. So, Alice, you said your central vision was unaffected. Is that correct?
Correct.
Okay. Were you wearing any corrective lenses to help with this condition?
Yes.
Okay. And you completely saw clearly the pedestrian walk right in front of you, and your central vision turned south out of the median, correct?
Correct.
And that's when you heard the accident, when she was out of the crosswalk?
Correct.
Okay, thank you. Now, Alice, I'm a little confused as to why you didn't come forward as original witness. Why didn't you step forward as original witness?
I didn't want it to upset the family.
What would upset the family, Alice?
That she wasn't in the crosswalk.
Okay, thank you. Your Honor, the defense passes this witness.
Any cross?
Yes, Your Honor.
Okay.
May I leave the plaintiff's table to go to the board?
Yes, you may.
Okay. Could I direct your attention to Exhibit 10 in the trial notebook? And what is it?
It's a picture of the intersection.
Is that a fair and accurate picture of the intersection that you are on duty? Were on duty as a crossing guard?
Not completely, no.
Is the diagram a fair and accurate depiction of the intersection you are on duty?
Yes, the diagram is, but not the photo.
Your Honor, Exhibit 10 has already been admitted in evidence and has already been admitted on to be shown to the jury. Can we project it to the jury on the overhead?
Yes, you may.
Now, you stated that you boy almost get hit, correct?
Correct.
And before the boy ran out into the crosswalk, you told that boy to stop, didn't you?
Correct.
And when you told the boy to stop, he didn't stop, did he?
No, he's a small child. They sometimes don't listen.
And unfortunately, he didn't get hit.
Unfortunately?
No, I'm saying, fortunately, he didn't get hit, but he made it to the other side, and you left your duty post right here to walk all the way over here to reprimand this boy, didn't you?
Actually, my duty post is that part of the intersection, so I went to the other part of the intersection where it was also my duty to watch children.
Okay, and when you got to this intersection, you took a knee, didn't you, to talk to this boy?
I took a what?
A knee to talk to this boy.
I don't knee anybody, no.
You took a knee down on the floor.
Oh, I kneeled. I kneeled?
In your deposition, you stated that you took a knee on the...
I kneeled.
Okay, you kneeled on the ground. And when you kneeled on the ground, that's when you saw, across from you, the children. At the original part where your duty post was, you saw them standing over here, didn't you?
Actually, I never mentioned the children in my deposition.
Can I direct your attention to line 13?
Sure.
In your deposition.
Counsel, is there an exhibit number?
The exhibit number is... Sorry. 37. You stated that as you saw, okay, well, as you saw Mrs. Potter walk out into the crosswalk, you stated that you also were keeping an eye out of your children at the corner right over here.
I think maybe you're reading a different deposition because it doesn't state it in mine.
Where's our deposition? At the time I was watching Mrs. Potter, I was also watching the children on the corner. Line number 23.
Oh, 23. I thought you said 13.
I'm sorry, I got the numbers mixed up.
Okay, let me read line 23. It's been a while since I gave my deposition.
And once you, when you were looking at Mrs. Potter take a couple steps in the crosswalk, you were on a knee talking to the boy, reprimanding him, and you were also watching the children at your duty post that you left originally to talk to the boy, correct?
Okay, what line 23 says was, at the time I was watching Mrs. Potter, I was actually watching other children. I was watching this child right in front of me, and then so I kneeled down so I had a clear central line of vision, and I saw Mrs. Potter.
Yes.
That's how the deposition reads. So it doesn't read that I was watching other children. I
But-
was watching that corner as I had stated. So I
Yes,
just
you were
wanted to
watching the
clarify.
children, you were watching Mrs. Potter, and you were talking to the boy all at once, correct?
Well, that was the children at the corner, yes, that is
And didn't you state
correct.
earlier that you have a degenerative eye condition?
Correct.
And that means that you have weakening in weakening in your peripheral vision. Am I correct?
It means it's starting to weaken?
But it was undiagnosed for a long time before the day of the incident, correct?
It was undiagnosed for a long time, yes.
And you were just starting to have problems with this, correct?
Correct.
At the day of the incident.
Well, I wouldn't say the day of the incident specifically.
At the time of the incident, you were just starting to have problems with it, correct?
Correct.
And you stated earlier that you saw Mrs. Potter turn south on the median. Sorry, I'm shaky, but turn south on the median while you were staring at the children and talking to the boy, correct?
A specific.
Overruled.
Specifically, I said, as I was watching Mrs. Potter. So Mrs. Potter was actually in my central line of vision then.
And then when she took the south down the median, she wasn't because you were talking to the boy, correct?
But it says in my deposition that I was actually watching Mrs. Potter, as you pointed out.
And the children, which are on the opposite direction, correct?
The children, yeah, I was watching the children at the same time.
After you saw Mrs. Potter take a couple of steps in the intersection, you didn't talk to Mrs. Potter, did you? You didn't get up off your knee or anything, did you?
I couldn't have. Mrs. Potter was halfway across the intersection.
So she walked into this intersection. You didn't tell her anything.
Why would
and
I tell her anything? My
because
job is
Mrs.
to watch the children, not Mrs. Potter.
So you put a value on children, and you, as a crossing guard, your job is to make sure that pedestrians safely cross the crosswalk. You didn't.
Mrs. Potter is responsible for her own safety. I am not.
So you didn't even alert Mrs. Potter that it wasn't time for her to cross?
I did not alert her that she should not walk out in front of traffic.
Because she had a right of way to cross at that time, didn't she?
No, she did not. She stepped out into traffic outside of the crosswalk. It is not my duty as a crossing guard for a school district to notify an adult that they are in the wrong.
So you said that you saw her take a south on the median, but it was
Correct.
sawn through your peripheral vision, which is weakened and limited.
No, that was in my central vision at the time, as I have already stated.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. Once again, Alice, Mrs. Potter was not in the crosswalk at the time she was hit, correct?
Correct.
Thank you. Your Honor, no further questions.
Recross.
Yes, Your Honor. Did you see Mrs. Potter take a couple steps in the crosswalk?
Outside of the crosswalk?
Take a couple steps inside the crosswalk.
I saw Mrs. Potter take a couple steps inside the crosswalk.
Thank you. No
And
further
then I saw
questions,
her go
Your
down
Honor.
outside of it.
Redirect.
No, Your Honor.
Okay. Is the defense, may this witness be excused by the defense?
Yes, Your Honor.
May this witness be excused by the plaintiff?
Yes, Your Honor.
Very good. Ms. Mallory, you may be excused. Call your next witness.
Your Honor, the defense calls Charles Schrackle.
Mr. Schrackle. Mr. Schrackle, you remember you took an oath earlier in this trial? That oath applies to you now as you testify. Do you understand that?
I understand that.
Great. Okay. Have a seat, please, sir. You may proceed.
All right. Mr. Schrackle, can you please restate your name for the court?
My name is Charles Schrackle,
And what's your age, Charles?
38.
And where do you live?
I live in Nita City.
Do you have any family, Charles?
I have a wife, Emily.
Okay. And what do you do for work?
I own Schrackle Construction Company.
Okay. And how long have you been doing this work?
For 4 years now.
Okay. Now, Mr. Schrackle, let me take you back to the day of the accident. How did your morning start?
Oh, well, it started off at 6:45 a.m. I had a good night's rest, no alcohol the night before, and I don't take drugs. After I woke up, I went into the office and whole routine.
So basically, it was just another day, good night's rest, good day at work.
Yes,
another day at
sir.
work. Okay. And you went to work that day?
Yes.
All right. Thank you. Now, what exactly did that work consist of the day of the accident?
Well, I went out to our holiday park site, and I helped the people there, and then I headed to Nita Builder Supply at around 2:30.
Okay. So at 2:30, you arrived at Nita Builder Supply. Is that correct?
Yes, that's correct.
Okay. And did you have any more work after Nita Builder Supply?
Yes, after leaving Nita, I had to be at an appointment with Mr. Clark Poe.
Okay. Mr. Clark Poe, this appointment was at what time?
It was at 3:30.
Okay. Now, Mr. Schrackle, what time did you leave Nita Builder Supply?
I left it at about 10 after 3.
Okay. And so at 3:10, you left Nita Builder Supply, and you had a meeting at 3:30. Is this correct?
Yes, that's correct.
Okay. Did you make a phone call to Mr. Poe?
I did. After I left Nita Builder Supply, I called him, let him know I was running a little late. He said that I was okay. I didn't have to be there until 4 o'clock, so I wasn't in a rush.
Thank you. Now, Mr. Schrackle, what is the location of Nita Builder Supply related to the work site that you had to meet Mr. Poe at?
It's about 20 minutes away.
Okay. And during this time, you would have came to the scene of the accident, the intersection of Kirby and Mattis?
That is correct.
All right, thank you. Now, Mr. Schrackle, let me call your attention to exhibit number 3. Your Honor, can we show exhibit number 3 to the jury?
Yes, sir.
Thank you. Okay. Mr. Schrackle, can you please point on the diagram where you came up to the intersection?
Yeah, I came up to it right there in the left turn lane.
Okay. Mr. Schrackle, were you on the phone at this time?
I don't remember.
Okay, thank you. Now let me call your attention to exhibit number 16. Your Honor, can we publish exhibit number 16 to the jury?
Yes, sir.
Thank you. Okay, Mr. Schrackle, can you please explain the viewpoint of this picture?
Yes, that would have been the turn lane I would have approached the intersection at.
Okay, can you please point out where you were where you came up to the intersection?
Right there.
Okay.
Right there.
And what did you observe when you came to the intersection? Was the light green or was the light red?
The light was green.
Okay.
I rolled through the line there, and I let another car pass by, and that's when I started to make my left-hand turn. I had my foot on the brake the whole time, as I normally do when I make turns.
Okay. What did you observe any other factors?
Well, I noticed on the corner of White Castle there was a crossing guard, and then I looked over and I saw some school children on the corner of Jim Marshall's tires.
Okay, can you please point out on the picture above where the school children would have been? On the picture above, please. Thank you, Mr. Schrackle. Now let me call your attention to exhibit number 17. Your Honor, may we publish exhibit number 17 to the jury?
Yes, sir.
Thank you. Now, Mr. Schrackle, can you please point out where the crossing guard was in the school children? On the map above.
And then right there.
Okay, thank you. Now, Mr. Schrackle, you were looking forward at this time, correct?
Correct.
Or else, how else could you have seen them?
Yes, that is correct.
Okay, and you were keeping a proper and reasonable lookout, especially for the children?
I was. It's one of my biggest fears. I had my foot on the brake. I wanted to make sure none of them ran out into the crosswalk.
All right, thank you, Mr. Schrackle. Now, let me ask you to take me through the accident. what happened as you made the turn.
Well, as I made the turn, as I said, I had my foot on the brake the whole time. I was paying close attention to the children. After I passed the crosswalk, it would have been a couple seconds, and that's when I felt the impact.
Okay, so you hit the pedestrian out of the crosswalk.
Yes, that is correct.
All right, thank you, Mr. Strackle. Let me call your attention to exhibit number 10. Your Honor, may we call this exhibit number 10 to the jury?
Yes, sir.
Thank you. All right, Mr. Strackle, to the best of your ability, can you please point out where you struck the pedestrian in this picture above?
It would have been several feet south of this car here, probably closer to right here.
So she was clearly not in the crosswalk, correct?
Yes.
Okay. And you're keeping a proper and reasonable lookout for the children. It was just unexpected that an adult would have jumped out in front of oncoming traffic.
Yes, that is correct.
Okay, thank you, Mr. Strackle. Now, after the accident, did you talk with anybody?
The officer who came on the scene.
And did that officer fill out a police report?
She did.
And did she give you any citations?
Oh, she did not. She did not feel I was driving recklessly.
She didn't give you any citations because she concluded that the pedestrian was out of the crosswalk and you weren't in the wrong?
Yes, that is correct.
Okay, thank you, Mr. Strackle. Now, let me quickly retouch on the subject of your truck, that Toyota Tacoma. What is the condition of your truck?
It's in good working condition. I had it inspected about a month earlier. The tires on it were in good condition.
Okay, so your truck was in pretty mint condition.
Yeah, it was working fine.
Okay, thank you. Now, as you stated earlier, you didn't have that meeting with Mr. Poe that day?
No, I did not. I did not meet with him until the next day.
Okay, and that next day you met with Mr. Poe with the dollar sum, however, that he was going to pay you was lower.
Yes, there was a reduction in pay.
Right.
But compared to what happened to Miss Potter, it was insignificant. I was just really sorry about that.
Okay, thank you, Mr. Strackle.
Any cross-examination?
Yes, Your Honor.
You may proceed.
As a driver, you have a duty to watch out for everyone, not just children. Isn't that correct?
Yeah, that's correct.
You testified at your deposition that you've been at the Greenbrier site before. Isn't that correct?
Yes.
So you've been at the signal light before. Isn't that true?
Yes, I've been to Madison Kirby.
Okay. So you knew it was a busy intersection, didn't you?
Yeah, it was a busy time of day.
So you're familiar with the intersection.
Yes, I'm familiar with the intersection.
So you would have known to watch out not only for children, but also for any pedestrian. Isn't that true?
I scanned the crosswalk. I was using proper care.
Now, you stated earlier that you didn't look at your speedometer. Isn't that correct?
Yes, that's correct. I was at a very slow stop.
Okay. So you didn't check your speed at any time during the incident, did you?
No, I did not.
So you didn't know how fast you were going. Isn't that correct?
I mean, I'd estimate about 20 miles an hour.
But you're not sure. Isn't that true?
I'm not sure, no.
So you could have gone faster than 20 miles per hour. Isn't that
could've.
correct? Okay. And you stated just a few seconds ago that that when you passed the intersection, you only passed, it was a few seconds after you passed the intersection when you hit Mrs. Potter. Isn't that correct?
Yes, that's correct.
Okay. Could you turn to Exhibit 12, your exhibit book? Is it a fair and accurate depiction of the intersection?
Yes, it is.
Your Honor, I offer Exhibit 12 has already been admitted. Can I display it?
Yes, ma'am.
Thank you. So when you made the turn, this would be the corner where the children are, correct?
Yes, that's correct.
Okay. And so when you made the turn, did you look back at any time?
No.
Okay. So you said the crosswalk is right here, isn't that correct? And the children would be at the corner, isn't that true? Okay, the crosswalk is right here, isn't this correct?
Yes, that's the crosswalk.
And the children would be right here, isn't that true?
Yes.
So if you stated that when you turned, you would have been around over here when you hit Mrs. Potter, isn't that correct?
No, that is not correct.
Okay. You stated that you would have been after the
Yes,
crosswalk.
it was,
Isn't that
it was
correct?
several seconds past,
Okay.
yes.
So several seconds passed,
The crosswalk.
and you said you don't remember turning your head at any time. Isn't that correct? I mean,
Yeah, I don't remember.
but you were looking at the children right here.
Yes, I saw the children.
So when you turned onto Mattis, you were looking at the children, and you never turned your head back.
I don't remember.
Okay, so it could be possible that she was in the crosswalk. Isn't that true?
No,
Well,
that's not true.
You stated that you just stated with the defense that Potter was clearly out of the crosswalk, didn't you?
Yes, that's what I stated.
But you didn't see her when you turned onto Mattis. Isn't that correct?
No, I did not see
So
her.
you wouldn't know if she was in the crosswalk or not. Isn't that true?
Well, the impact took place several seconds past
But
the
you didn't-
crosswalk.
But you didn't see her outside of the crosswalk. Isn't that correct?
I didn't see her until after the accident.
So you didn't know if she was in the crosswalk or not. Isn't that true?
Well, the impact happened after the crosswalk.
But you were looking at the children. Isn't that correct?
Yes, that is correct.
So how would you know if you passed the crosswalk or not?
I don't know.
Your Honor, we passed the witness.
Redirect?
Yes, Your Honor. Your Honor, can we bring up exhibit number 10 again, please?
Yes, sir.
Thank you. Mr. Strackle, or once again, Mr. Strackle, can you please restate where you felt the impact in this picture above?
I'm sorry.
yeah.
I'm sorry, counsel. Is that the exhibit that was admitted into evidence as Exhibit 10?
Yes. Well, the one that is on the
Overhead.
What exhibit was admitted into evidence as Exhibit 10?
the one in the projector. I mean, on the PowerPoint.
Right. This exhibit is not admitted into evidence, correct? Okay. So the other Exhibit 10 that is admitted is, would you like that one?
Yes, Your Honor. The previous one, the previous
Okay.
exhibit 10.
All right. Or would you like to offer this one?
The one they just had, the exhibit 10, that exhibit.
Okay.
Is the one I was referring to. Thank you.
Okay, and so to avoid confusion, the one that is admitted, the one that's going up in color is Exhibit 10, and the other exhibit I'm going to refer to as 10A for identification only. Any objection
No, Your Honor.
from the plaintiff?
No, Your Honor.
Okay. All right, proceed.
While that's waiting to load, Mr. Strackle, of course you were looking at the kids because you were making a turn, correct?
Yes, that's correct.
And you were looking at them while you were making the turn, that's correct?
Yes.
And you didn't see Mrs. Potter step out in front of you?
No, I did not.
And you did nothing to make Mrs. Potter step out in front of you, is that correct?
Yes, that is correct.
Her own actions that took her off the crosswalk.
Yes.
Or off the median, out of the crosswalk, is that correct?
Yes, that's correct.
Okay. Okay, once again, Mr. Strackle, can you please point to the place where you felt the impact of the pedestrian?
It would have been several feet south of this car. Probably right about there.
Okay, thank you. And at that time, while you were looking at the kids making the turn, you were drawing your attention back to the roadway because they had already passed you, and that's when you felt the impact, correct?
Yes, that's correct.
But you did nothing to make her step off that curb.
I did not.
It was her own actions, that's correct.
It was her own actions.
All right, thank you, Ms. Strackle.
Cross?
Yes, Your Honor.
Proceed.
So you didn't see her on the hood of your car, did you?
No, I didn't see her until after the accident.
Exactly. And you just stated that that's when you looked in front of you and that's when you hit her. Isn't that true?
Yeah, I don't know. What, can you restate the question?
You just stated that after you looked at the children, you looked in front of you, didn't you?
Yes, that's correct.
But you didn't see her on the hood of her car, on the hood of your car when you slammed into
No,
her,
I
did
didn't
you?
see her until after the accident.
You didn't see her flying in the air, did you?
I did not.
The first time you saw her was when she was under your car, your
Yes,
truck.
after
Isn't
the
that
accident,
true?
yes.
So that could have been that's why she wasn't in the crosswalk, because you had hit her outside of the crosswalk. Isn't that true?
I don't know.
Now let me direct you to this exhibit. What light is it right here?
A green light.
And are there pedestrians walking in the crosswalk?
There are pedestrians.
No more questions, Your Honor.
Redirect.
Once again, Mr. Schreckle, let me reiterate. You were acting like a reasonable driver, keeping a proper lookout, and you did nothing to cause her to step off that curb outside the crosswalk.
Yes, that's
It was
correct.
her own actions that took her out. Is that correct?
Yes, that is correct.
Thank you, Your Honor. Thank you, Mr. Schreckle.
Recross.
No more questions, Your Honor.
Okay. All right, you may step down, Mr. Schreckle. Call your next witness.
Your Honor, would the doctor cancel the stand?
Dr. Buchanan, has this witness been sworn?
No, ma'am.
Okay. Raise your right hand and be sworn. Do you swear to tell the truth, the whole truth, and nothing but the truth? Yes, ma'am. Okay, have a seat, please, sir. You may proceed.
Thank you. Please state your name for the court.
My name is Edward Buchanan.
And what is your educational background, Dr. Buchanan?
I have a PhD in economics from Nita University, and I also have a bachelor's in economics from the same university.
What is your employment history, Dr. Buchanan?
From 2001 to 2006, I work as a private equity consultant. From 2006 to the present, I'm currently employed by the Nita University, my current position is that of the assistant professor of economics at Nita University.
Thank you. And what is your connection to this case?
I was hired by the defense in this case to represent them as an expert witness.
Thank you. And what items did you analyze for this case?
In this case, I analyzed the petitioner's original petition as well as the defendant's answer, in addition to all the testimonies submitted and depositions submitted to the court, and all evidence containing submitted to the court, in addition to conducting a personal review of the H&R department's policy, or the H&R policies of the Technosoft Corporation.
Did you analyze any other calculations or reports or?
Yes, I did examine the report of Dr. Glenn, as well as a memorandum written by her assistant.
Now, Dr. Buchanan, overall, what is your opinion of the economic loss to the plaintiff?
Overall, my opinion of the economic loss to the plaintiff is around $334,000.
$334,000.
Approximately, yes.
Thank you. And after reading Dr. Glenn's report, what would you say, what is her opinion of the economic loss to the plaintiff?
Approximately, it is about $1.5 million.
Okay. And can you turn to Exhibit 47 in your binder?
Yes, one moment. Okay, yes.
What is, without giving any details, what is this exhibit?
It is my expert report that I wrote and submitted to the court.
Is it an accurate depiction of your report?
Yes.
Thank you. Your Honor, the defense offers Exhibit 47 as evidence.
I show Exhibit 40.
47, the numbers are different.
47?
That would be my,
46, sorry.
47 is a copy of my resume.
Okay. Well, Exhibit 46 is?
Exhibit 46 is my report that was submitted to the court, my expert opinion.
And is it accurate?
Yes.
Your Honor, the defense offers Exhibit 46 as evidence.
I show Exhibit 46 as an exhibit that's previously been agreed to by both sides, and so there is no objection from the plaintiff.
No
to
objection,
admission.
Your Honor.
It's admitted.
Okay. Now turn to Exhibit 47. What is this exhibit?
This is a general resume and a prior history of my involvement in other events outside of this case.
Do you recognize it?
Yes.
And is it an accurate depiction of your resume?
Yes, ma'am.
Your Honor, the defense offers Exhibit 47 as evidence.
I show Exhibit 47 as an exhibit that's been agreed to previously by both sides. Is there any objection by the plaintiff?
No, Your Honor.
Okay, admitted.
May we publish this exhibit to the jury?
Yes, ma'am.
Thank you. May the witness go to the elbow to put his exhibit on?
Certainly.
Dr. Buchanan, have you ever published any books or magazines before?
Yes.
What kind of articles have you written?
I've published multiple articles, some in the Harvard Review, Policy Review, others in the Journal of Economics. Generally, they range in subjects from the value of household labor to what is your economic loss worth.
Thank you. Now, have you testified in any other matters, lawsuits?
I have testified in 3 prior cases to this one.
And did you testify for the plaintiff or the defense?
Both.
Thank you. Now, what were your basis for your opinion?
The basis for my opinion is in 5 parts after I reviewed all the factors of this case. The first was the value of economic, the value of earnings Mrs. Potter would have received had she survived at her current position at Technosoft, and applying that forward. The second would have been the amount of raises she would have received year on year. The second part of my, or the third part of my review would have been the amount of fringe benefits she would have received as an employee of Technosoft Corporation. The fourth would have been the value of the consumption rate at as an individual human being. This is then amount that's deducted for Mrs. Potter spending money on herself, separate from the marriage. And then the fifth amount would have been the value of her own household work.
Now, after analyzing all your documents, what would you say is the loss to the plaintiff for the value of earnings for Mrs. Potter in the future?
In terms of earnings, I believe that Mrs. Potter would have the value of the loss of earnings was about $680,000 in today's value.
$680,000. Now, what was Dr. Roberta Glenn's opinion?
Dr. Roberta Glenn values the opinion closer to $1.9 million.
$1.9 million?
Yes.
Does she calculate future value or current value?
This is counted for the future value, but discounted at the current rate.
Okay, thank you. Now, in regards to the raises for Mrs. Potter, what would you say is the total loss to the plaintiff?
That is valued in future value earnings, as that is applied from the present to the future moment we expect Mrs. Potter to retire.
Okay. Now, what did you calculate for the loss?
Of raises, it goes back into earnings, it would still be about $680,000.
Thank you. And what was Dr. Roberta Glenn's opinion?
As stated earlier, the same rules apply that Dr. Glenn expects that Mrs. Potter would have lost, the loss to the Potter estate would have been about $1.9 million.
Thank you. And now, did you analyze or did you go over the retirement age for Mrs. Potter?
Yes.
And what did you determine that to be?
I believe that Mrs. Potter would have continued working at Technosoft Corporation until the age of, at full time at the age of 50 at her current position. From that point, she would have retired part-time in compliance with policies at Technosoft Corporation and continued to work part-time at Technosoft at her current position until the age of 55.
How did you determine this?
I reviewed the testimony of Jeffrey Potter as well as the deposition of Daniel Sloan, in addition to the conducted an independent interview of the policies of the Technosoft Corporation and the letters written by Mr. Jeffrey Potter concerning Mrs. Potter's retirement.
Thank you. And what did Dr. Roberta Glenn, what was Dr. Roberta Glenn's opinion of the retirement age for Mrs. Potter?
She believes that Mrs. Potter would have received a promotion and worked at Technosoft Corporation until the age of 60 at full time.
Okay. And now, what did you calculate for her consumption?
Using the ratio provided by the U.S. Department of Labor, we estimate that Mrs. Potter would have consumed 75.1% of her income. This is applied to the total amount that amounts to about $510,000.
510?
Yes.
And what was Dr. Roberta Glenn's opinion of Mrs. Potter's consumption in the future?
Dr. Glenn uses the same method to examine Mrs. Potter's consumption, but as her base is higher, she estimates that the amount is at $1.4 million. Approximately.
1.4 million.
Yes.
Now, what in your words, what is the definition of consumption?
Consumption is money that Mrs. Potter would have spent on herself outside the marriage. This is money that she would have spent at work. This is money she would have spent on food for herself. This is money she would have spent on clothes for herself or car for herself. This is money that she benefited directly from, not Mr. Potter as part of the marriage. As a result, this is deducted from the total amount.
Okay, thank you. Now, also you talked about Mrs. Potter's fringe benefits.
Yes.
Now, what did you calculate to determine her the estate's loss?
For benefits, I reviewed the amount of benefits Mrs. Potter had received from the beginning of her employment in 1998 to the present, to the time of her death. This amount averages, if we were to remove one bonus she received for a 10-year anniversary at Technosoft Corporation, this amount amounts to about 17.5%.
Why did you remove the bonus?
There is no other bonus of the similar type in the future, that, to the best of my knowledge, or to the best of the knowledge of the people at Technosoft Corporation. This bonus was only applied because a 10-year anniversary that Mrs. Potter had worked for Technosoft. The amount was about $2,000.
Did you speak to anyone or did you review any reports to determine that they didn't offer that for the 20th anniversary of Mrs. Potter working there?
Yes, I spoke to the H&R manager of the Technosoft Corporation.
So do they not offer a 20 or bonus for working there 20 years?
Not within the confines of what I reviewed in this case.
Thank you. And now, what did you calculate for the value of her household work?
Mrs. Potter's household work applied within this state, of course, is valued at 2 hours per day, every day of the week, every day of the year, basically up until the time limit that's given. In this case, up until the age of 60. I value the amount at a minimum wage. The total of this amount is around $45,000, approximately.
Thank you. Now, what was Dr. Roberta Glenn's opinion?
Dr. Roberta Glenn estimates that the amount will be somewhere above 600, close to about $680,000 or $690,000.
$600,000.
Mhm.
Now, did you calculate salary for household work, or did you do per hour?
I used the amount that's generally applied within this state as generally people within this state, if they were to value the amount of the value of the regular household work at minimum wage. So that's the current amount that applied to this state.
So was that per hour or
Yes.
salary? Thank you. Now, so you valued at minimum wage.
Yes.
Now, what was Dr. Roberta Glenn's opinion of the value for per hour?
Dr. Roberta Glenn estimates that the amount would have been closer to her employment current amount they received hourly at her occupation, which is $41 per hour.
Now, can you tell us what is the definition of household work?
Household work is generally any work that you do at the household to upkeep the house. This is not stuff that you benefit from, but the entire household benefits from. Generally, this includes cutting the grass, gardening, doing laundry, dishes, just anything you would do at your own house. This is all normal tasks that you do regularly.
Would Mrs. Potter use her skills that she uses at work?
I do not believe that she would be training professionals over the use of software technology, so I do not believe that she would be using her skills or her experience, no.
Thank you. Now, can you state again what your overall opinion of the total loss for the plaintiff is?
Yes, I believe that the total amount of loss at today's value is around $333,719.
And what was Dr. Glenn's opinion of the total loss to the plaintiff in this matter?
Dr. Glenn's opinion is in excess of $1.5 million.
Did you prepare any visual aids to help the jury better understand your calculations?
Yes, I did prepare a demonstrative aid comparing the summary of my report and Mrs. Glenn's report.
Thank you. Your Honor, may we show this visual aid to the plaintiff?
Yes. Oh, wait. Yes, yes.
Demonstrative aid.
Your Honor, may we show this visual aid to the jury?
Any response?
Your Honor, seeing that this wasn't reviewed in the pretrial agreement, we would not like this to be shown to the jury.
Are you objecting?
Yes.
Okay.
Yes,
And
ma'am.
what is your objection?
Outside the scope of the problem.
Your Honor, these are the exact calculations that both doctors did in this opinion. So it's calculations of both the loss of the plaintiffs and the loss that our expert.
Okay, all right. Well, this document, I haven't seen either, and it's not identified in any way, nor is it marked as any kind of an exhibit. It's not being offered into evidence. It's merely being offered, as I understand it, as a demonstrative aid to the jury.
Yes, ma'am.
At this time, I'm going to sustain the objection.
Dr. Buchanan, so if you had to put a percentage of the difference between you and Dr. Glenn's opinion, what would you say is the difference?
Factoring the values given for future value earnings, the future fringe benefits, the future value hospital work, adding them together and subtracting the amount of personal consumption, the total, this comes around to the amount of my and Dr. Glenn's amounts. If we were to use my amount as a base, then that would be about $333,000. Then we were to apply that to Dr. Glenn's amount, then the percentage increase from 100% will be to 500% in Dr. Glenn's amount.
Now your calculations are very different. So you created the visual aid to help the jury?
Yes.
Okay. So would the visual aid help the jury better see the numbers that you calculated?
The visual aids merely lists the amount given in my rebuttal on page 63 of the trial notebook versus the rebuttal or Mrs. Glenn's summary on page 41.
So the visual aid basically is a summary of both you and Dr. Glenn's analysis of the value of earnings and the fringe benefits and the household work?
Yes, at the discounted value.
At the discounted value. Okay. You want to maybe show the visual aid to help the jury?
Would you identify it?
It's a summary restatement of both reports. They're both fringe benefits and all of their Mrs. Potter's earnings for household work, for consumption. And it compares both Dr. Glenn's report and Dr. Buchanan's report.
Objection, Your Honor.
What is your...
This document has not been authenticated.
Do you have any other objection?
Your Honor, maybe approach the bench.
Yes.
All this is a printout of both reports, both summaries that have been admitted into evidence side by side. It better show the
jury of both analysis.
Okay.
I show you
Well,
before I
okay. Okay. All right. Well. Okay, so all right, I'm prepared to make a ruling, and I'm going to admit it. It needs a better title, so we can refer to it in the record concisely, okay, for the reporter's record, and you will be able to cross-examine on anything that you think is not accurate, okay? All right. The document, which I am going to call for identification, is the visual aid of expert witnesses. It will be allowed, I'm going to allow it to be displayed to the jury.
Thank you, Your Honor.
As a visual aid at this point, okay?
Thank you. May the witness approach the Elmo to show the judge? Oh, may I approach the witness?
Yes, ma'am.
Your Honor, may the witness approach the Elmo to show it to the jury?
Yes, ma'am.
Dr. Buchanan, could you point out your summary or your opinion in this matter to the economic loss of the plaintiff one more time? For once.
Okay, I guess to point it out will be on the bottom line or in the final row of the column and totals A, B, C, D to the third column here. The summary underlined is $333,718.
And what was Dr. Glenn's opinion?
Dr. Glenn is in the same row on in the next column to the right at $1,532,021.
Thank you. Now, what do A, B, and C? What are they?
A, B, and C is the future value of after the discounted value of 6%. Those are the earnings Mrs. Potter would have received from the time frame that both me and Mrs. Glenn would have calculated, as well as the benefits we individually calculated, the value of our household work that we each assigned, and the personal consumption that we both assigned.
Now, Dr. Buchanan, why do you take out D?
D is the personal consumption Mrs. Potter would have spent on herself outside the marriage. This is money that the estate would not benefit from had she had survived.
Thank you, Dr. Buchanan. Your Honor, the defense passes this witness.
Okay, any cross?
Yes, Your Honor.
Proceed.
Dr. Buchanan, you stated in your testimony that minimum wage would be sufficient for household work. Is that correct?
Yes, within this state.
Within the state. So you're saying minimum wage is sufficient for all household work, no matter what it is, no matter how long it is. Is that correct?
Minimum wage.
Is that what you're saying? It's a yes or no question.
Depending on the task.
It's a yes or no question. Just no depends. It's a yes or no question.
I already answered yes.
Okay, thank you. No further questions.
Redirect.
No, Your Honor.
Okay. May this witness be excused by defense?
Yes, Your Honor.
By plaintiff?
Yes, Your Honor.
Okay. Dr. Buchanan, you may step down.
Thank you.
Call your next witness, please.
Your Honor, the defense calls Juanita Williams.
Juanita Williams, has this witness been sworn?
No, Your Honor, she has not.
Ms. Williams, please approach. Raise your right hand. Do you swear to tell the truth, nothing but the truth, and only the truth? Okay. Have a seat, please.
May I proceed, Your Honor?
Yes, you may.
Thank you. Can you please state your name for the court?
Juanita Williams
And where do you live, Juanita?
in Nita City.
Do you have any family?
I do. I have a 10-year-old named Victoria and a 3-year-old named Joshua.
So you're a single mother, Juanita?
I am.
All right, thank you. Do you know either of the parties involved in this case?
No, I do not.
All right, thank you. Juanita, what is your connection with this case?
I had just driven past the intersection when the accident occurred.
Okay, what were you doing around the time the accident occurred?
I had just picked my daughter up from school, and I was going to the daycare to pick up Joshua.
And about what time would this have been?
3:30 in the afternoon.
All right, thank you. Let me call your attention to exhibit number 3. Your Honor, may we publish exhibit number 3 to the jury?
Yes, you may.
Thank you. There we go. All right, Juanita, can you please point to this diagram where you came up to the intersection?
I was here.
Okay, and when you came up to the intersection, did you make a stop?
I did. I had to stop for the red light.
Okay, thank you. Now, Juanita, take me through this accident, and let me call your attention to exhibit number 16. Your Honor, may I publish exhibit number 16 to the jury?
Yes, you may.
Thank you. Okay, Juanita, in the picture above, can you please point out where you came up to the intersection?
I was right there.
Okay. Now, what exactly did you observe of the accident?
Well, I drove through the intersection. The light turned green, so I went to go through the intersection. And a few feet after the intersection, my daughter exclaimed, "Mom, somebody's been hit."
So you didn't see the accident?
I did not.
Okay, you only knew about this accident because your daughter exclaimed that somebody had just been hit?
Correct.
Okay. What were your actions after your daughter exclaimed this?
I turned around and we pulled into the White Castle parking lot.
Okay, on the diagram below, can you please point to where you pulled in?
Sure.
Okay, and what did you observe while you were there?
I saw the dark-haired woman underneath the pickup truck.
All right, thank you, Juanita. Your Honor, the defense passes this witness.
Any cross?
Yes, Your Honor.
Proceed.
Your Honor, may I project Exhibit 10 onto the overhead?
Yes, you may.
Now, according to the diagram, you were stopped at a red light right here. Isn't that right?
Correct.
And while you were stopped, you saw a man in this direction come to a stop at this left turn, correct?
I saw a man there, yes, in a pickup truck.
And you noticed that this man had his hand up to his ear as if he was on his cell phone, but you weren't really sure, were you?
No, that's not actually what I said. I said I noticed he had his hand up. It could have just been that he had his hand up by his ear, or he could have been on his cell phone, but I wasn't sure.
You weren't sure because you were looking ahead of you, correct?
He was ahead of me, yes, so I was looking at him who was ahead of me.
But he wasn't directly ahead of you. He was to your left. Am I correct?
I have more than tunnel vision, so
No.
I could see. When you look across from you, you see more than a straight line. So
Okay.
yes, I was able to see.
When your light turned green, you proceeded to cross the intersection, correct?
Correct.
And your light was green like this, right?
Well, it was a different,
The traffic light was green like this, correct?
I guess.
But you were stopped right here, and the traffic light was green right here, correct?
Why don't you show the whole intersection? Because there's probably another traffic light. So you're asking me an incomplete question.
Well, the traffic light that is for right here, for this traffic that's going straight right here, your traffic light right here was green, correct?
The traffic light at the intersection was green. I'm not willing to say that the traffic light stops at the point where it is stopped on that photo, because
Okay,
your
but the
photo is
traffic-
blocked by a bus.
Okay, but the traffic light in the intersection, according to the diagram, would be green for right here, correct?
The traffic light at the intersection was green. I'm not going to debate the placement of a light on a picture where
In
I
this
cannot
general
see
area,
it.
the traffic light would be green. Well, according to the photo, where do you see the pedestrians in the intersection? In the photo, I mean.
Actually, I don't see any pedestrians in the intersection because my view is actually blocked.
Where do you see the people walking?
Would you like me to stand up and walk? Because right now I can see wood right here and an aid,
Okay.
a little diagram right there.
So while these pedestrians are in the crosswalk, the light is green, and you stated that you proceeded to go while your light was green, correct? On the diagram. You proceeded to go
Correct.
straight. And it was only a couple seconds after hearing your daughter hearing your daughter say somebody was hit that you were a couple of feet from the intersection, correct?
Please restate that.
After the light turned green, you were a couple feet from this intersection, and that's when your daughter said that somebody was hit, correct?
I was a couple feet past the intersection when my daughter explained, "Mom, somebody's been hit."
And you saw a man right after you passed the intersection turn onto Mattis, correct?
No.
What did you see then? What did you see this car do? The truck that was stopped, the man that was here stopped to take a left. What did you see him do after you crossed the intersection?
I don't know.
You saw him take a left onto Mattis right after you crossed.
I don't know.
Can I direct your attention to your deposition? It's okay. Line number 13. Could you read it out loud to the jury?
Counsel, will you identify the document you're speaking of?
It is exhibit number 36 and number 12 and 13.
Well, let's take it one at a time. And 36 is not admitted.
Yeah. Do you remember testifying on December 12, 2011 in a deposition?
Yes.
And you understand today and you understand then that you were under oath?
Yes.
Your Honor, plaintiff offers exhibit 36 into evidence.
What is Exhibit 36?
It's a deposition.
Okay. Deposition of?
Deposition of Juanita Williams.
Objection, Your Honor. This document is irrelevant. She already stated she did not see the accident occur.
Are we talking about exhibit? Excuse me. Wait. Are we talking about Exhibit 36?
No.
35. I'm sorry.
35. Okay. 35 I show is agreed by both parties to be admitted. Is that correct, counsel for defense?
No, Your Honor. We object.
Well, wait a minute.
Go.
Was it not agreed before trial? Okay. All right, so admitted.
Could you read line 12 and 13 of your deposition?
Sure. Ear. The light changed to green. He waited until I passed, and with the light still green, he turned southwest on Mattis. The pickup truck took the turn a little fast, maybe at about.
Thank you, Your Honor. Plaintiff is done with the witness.
Okay, any
Yes, Your
redirect? Go ahead.
Juanita, once again, you didn't see the accident occur. Is
I
that
did
correct?
not, no.
Okay, thank you.
Redirect?
No, Your Honor. We're complete.
May this witness be excused by the defense?
She may, Your Honor.
By the plaintiff?
She may, Your Honor.
You may step down and resume your normal activity. Call your next witness.
Your Honor, the defense called Victoria Williams to the stand.
Victoria Williams. Has this witness been sworn?
No, ma'am.
Miss Williams, will you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Have a seat, please, ma'am. You may proceed.
Please state your name for the court.
Victoria Williams.
And how old are you, Victoria?
I'm 10 years old.
Your Honor, I asked for a little leeway because of her age.
Well, let's take it as it comes. Okay. And has this witness? You may want to qualify this witness to testify first. As competent.
Okay. Victoria, have you ever been in a courtroom before?
No, ma'am.
Now, I know it can be scary having all these people look at you, but I want this conversation to be between you and I.
Okay.
Now, how old are you again, Victoria?
I'm 10 years old.
Okay. And where do you go to school?
I go to Sun School.
And what is your mom's name?
My mom's name is Juanita Williams.
Did your mom bring you here today?
Yes, ma'am.
And did she let you testify today?
Yes, ma'am.
Thank you. Now, Victoria, do you have any siblings?
Yes, I have a brother.
And what is your brother's name?
Joshua.
And how old is Joshua?
He's 3.
Thank you. Now, Victoria, do you know the reason why you're here today?
I'm here because I saw the accident.
Now, take me back to the accident. What kind of accident was it? Was it 2 cars, an 18-wheeler, a bicycle?
It was a car accident with a truck and a lady with brown or black hair.
Okay, Victoria. Now, the lady's name is Mrs. Potter. Okay? But I'll call her lady with black or brown hair for you. Okay? Now, where were you headed?
My mom was driving me home from school.
Now, Victoria, please open up the binder in front of you to Exhibit 17. Do you need help?
No, I think I can do it. Okay.
Do you know that picture?
Yes, this looks like where the accident happened.
And do you recognize it to be the intersection?
Yes, ma'am.
Your Honor, may we show Exhibit 17?
Yes, you may.
Now, Victoria, take me back to the day of the accident. Can you point out where you were?
I was...
Do you need help with the pointer?
No, I think I have it. I was right there.
You're right there. Thank you.
Yes, ma'am.
Now, did your mom stop for any reason that day?
Yeah, she had to stop for a red light.
Okay. And so your mom was driving that day, right?
Yes, ma'am.
Okay. Now, what happened when the light turned green?
My mom drove forward and crossed the intersection.
So she crossed the intersection. And what happened next?
I turned to look behind me.
What were you looking at?
I was smiling and waving at my friends.
Can you tell me where your friends were?
They were in front of the tire shop.
They were in front of the tire shop. Can you go ahead and point it out on the picture where your friends were?
Okay. They were right there.
Now, can you do the same for the picture above?
They were, like, right there.
Thank you, Victoria. Now, do you remember how the weather was that day? Was it raining? Was it stormy?
It was sunny outside.
It was sunny? Now, if it was sunny, how could you still see your friends?
I just put my hand over my forehead like this to block the sun.
Now, looking at the picture, where was the sun? Do you remember?
It was in the sky.
Okay. Thank you, Victoria. Now, once your mom passed the intersection, do you remember where the lady with black or brown hair was?
Yes, she was on the center strip.
Can you explain to me what the center strip is?
That part in the middle of the road that's kind of raised.
So the median, right?
I think that's what it's called.
Well, can you go ahead and point it out to me on the diagram?
Yeah, it's that one.
Thank you, Victoria. Now, while you're pointing over there, could you tell me where the crosswalk is?
The crosswalk is right here.
So you were in the back seat of your mom's car, and your mom was passing the intersection, right?
Yes, ma'am.
So you turned to look at your friends that were in front of the tire shop.
Yes, ma'am.
All right. And let's see. So now you're looking back there. You see the woman on the center strip, right?
Yes, ma'am.
And what did she do next?
She just stepped right off in front of traffic.
Did you think she was going to do that?
No.
Did that surprise you?
Yeah, it made me scared.
Would you think that, well, why was it scary?
Because I would never just step in front of traffic.
Okay. Thank you, Victoria. Now, can you point to me where Mrs. Potter was?
She was right there.
Could you tell me and point it on the picture?
Like right over there.
Thank you. Now, do you remember what street Mrs. Potter was on, or the lady with black or brown hair?
She was on Mattis Avenue.
She was on Mattis Avenue?
Yes, ma'am.
Okay, can you point it out on the picture?
It's that one, and it's that street over here.
Thank you. Now, just by looking at the street on that picture, can you tell me how wide it is?
I don't know. I'm not really good with feet. If I had to guess, I would say probably a couple 100 feet.
A couple hundred? Just by looking
Yes,
at it, could it be
ma'am.
less?
I'm not sure. I'm not very good with feet.
Now, looking at the picture again, now where Mrs. Potter is, how far would you say she was away from Kirby?
I would say maybe 20 feet.
Okay, thank you. Could it be less?
Maybe 15, but I'd say 20.
Okay, thank you, Victoria. Now, earlier you pointed out where you were on the picture.
Yes,
Could you do
ma'am.
that for me again?
Okay, I was right there.
And now, going back to the accident, was Mrs. Potter at the crosswalk?
No, ma'am. She was not in the crosswalk.
Thank you, Victoria. Your Honor, the defense passes the witness.
Any cross?
Yes, Your Honor.
Okay, proceed.
Now, you stated that you actually saw Mrs. Potter get hit and that she was standing in the crosswalk, standing in the center strip.
Counsel, please sit down.
Sorry. You stated that you actually saw Mrs. Potter get hit by the truck and was standing in the center strip, correct?
Yes, ma'am.
Isn't it true that you also gave a police report that day?
I don't remember.
Well, you stated in your police report that you actually didn't see contact of her
I
getting hit.
remember telling my mom that I saw someone get hit.
But your mom didn't see anybody that day until you told her.
Argumentative.
Overruled.
You told the officer that you saw the lady running instead of standing on the center strip, didn't you?
No, ma'am. I never said that.
You told us today that you saw the lady standing in the center strip, but you told the officer that you saw the lady running.
No, ma'am. I never told the officer that.
Okay. You also told the officer that you didn't actually see contact that day, didn't you?
No, ma'am. I never said that.
Do you remember testifying under oath on December 12, 2011 in a
Yes.
deposition?
Yes, ma'am. I did.
Could I direct your attention to Exhibit 36 in the trial notebook?
Yes, ma'am.
Could you read out loud to the jury line 25?
I told my mom what happened.
Okay, sustain.
Your Honor, plaintiff offers Exhibit 36 into evidence.
According to my records, Exhibit 36 was previously agreed to by defense.
Yes, ma'am.
There being no objection, it's admitted into evidence.
Could you please read out loud to the jury line 25 in your deposition?
I told my mom what happened, that I thought the lady was hit by the truck. And she.
And so you thought you saw the lady that you stated earlier that you actually saw the lady. You only thought you saw her.
No, ma'am. I saw her.
Well, you just stated in your deposition that you told your mom that you thought you saw a lady
I
get
might
hit.
have been a little bit confused. I'm 10, but I saw her.
So you really weren't sure what you saw that day then?
No, I saw her get hit.
But you told
She
your mom
just
that you
stepped right
thought
off in
you
front of
saw
traffic.
the woman get hit. And you also told the officer that you saw the lady running.
Move along, counselor. Move along.
Plaintiff rest.
No further questions.
Okay. Any redirect?
Yes, ma'am.
Okay.
Now, Victoria, do you have anything to gain from being here today?
No, ma'am.
Do you know anybody here today?
I know my mom.
You know your mom?
Yes, ma'am.
That's the only person you know here today?
Yes, ma'am.
Okay. So why would you say you thought that you saw the lady?
I don't know. She just stepped right out in front of traffic.
Okay. It's okay, Victoria. Don't be scared. Your Honor, the defense passes the witness.
Recross?
No, Your Honor.
Okay. Is this witness excused by the defense?
Yes, ma'am.
By the plaintiff?
Yes, Your Honor.
All right, Victoria. Thank you for coming. You may step down. Call your next witness.
Your Honor, the defense calls Officer Michelle Young as a hostile witness, so we ask permission to ask leading questions.
Okay. Any response?
No.
All right. Okay, officer, you've been previously sworn, and you understand that that oath applies to you now as you testify, just as it applied to you earlier when you testified. I did. Okay, have a seat, please. You may proceed. Whoop, just a moment. Sorry. Okay, officer, are you settled?
I am.
Great. All right, you may proceed.
Thank you, Your Honor. Now, Officer Young, you're an officer of the law, is that correct?
Yes, that's correct.
Okay, and you've held this position for 7 years?
That's correct.
Okay. Now, Officer Young, did you take advantage of the accident reconstruction courses your department was offering?
Not yet.
Not yet, but so you still haven't taken it, though, correct?
That's correct.
Okay. So you're not qualified to give any measurements through the reconstruction of the accident, correct?
I use a general formula that the police station gives us.
Okay, but you're not qualified to give me measurements of the accident you reconstructed. That's correct, correct?
It's possible. I am not going to say correct, no. I've been doing it for 7 years.
But you haven't taken the class, though, correct, officer?
I have not.
Okay, thank you. And you also concluded that the pedestrian was out of the crosswalk when she was struck. That's correct.
That is correct.
Okay. And you didn't issue any citations to Mr. Schreikel. That's correct.
That's correct.
Okay. And you concluded that the pedestrian was struck outside the crosswalk 10 to 15 feet south of that. Is that correct?
I think what I said was 15 to 20 feet outside the crosswalk.
Okay. So she was max 20 feet south of the crosswalk.
Right.
Okay. Now, officer, since you didn't issue any citations to Mr. Schreikel, I conclude that he was acting like any reasonable driver would, correct? And that's why you didn't issue any citations?
Yes.
Did you conduct a field sobriety test?
No, I did not.
You didn't conclude that he wasn't under the influence of alcohol?
I didn't do a field sobriety test.
Did you conclude that he was not under the influence of alcohol?
I did.
Okay, thank you. Let me call your attention to exhibit number 1, officer. Specifically to the second page, the diagram in which you drew yourself. That's correct?
That's correct.
All right, thank you. Now, officer, take a look at that measurement, the second one, the one that measures from the opposite side of the crosswalk to the start of the skid.
Counsel, will you identify exhibit number 1, please? And this is only for identification, as it has not been admitted in evidence.
Exhibit number 1 is the police report.
Or why don't you do it through your witness?
Officer, do you recognize this exhibit?
I do. It's a police report that I created.
Thank you. Your Honor, the defense offers exhibit number 1 into evidence.
Any objection?
No, Your Honor.
Okay, admitted.
Thank you. Okay, once again on page 2, the diagram you drew, correct?
That's correct.
And the calculations you took, that's correct?
That's correct.
Okay. And you already previously stated that you had moved the truck and moved it back, that's correct?
That is correct.
Okay. Now the measurement you took from the opposite side of the crosswalk to the start of the skid, how many feet did you measure that up to be?
On the diagram,
Correct.
at 52.
That's to the bumper of the vehicle.
Okay, 38.
Okay, thank you. So, Officer Young, you concluded based on your measurement, okay, this isn't reconstructing the accident. We're just taking a simple measurement, correct, with a tape measure, correct?
Yes.
Okay. So any person could have done this, correct?
I don't know about any person.
Thank you, officer. But you concluded based off these measurements, and as you previously stated, that she was max 20 feet south of the crosswalk, that off these measurements, that you agree with Schrackle, Alice Mallory, and Victoria Williams that she was not in the crosswalk at the time she was hit. That's correct.
That is what I determined by my investigation.
All right, we're good. All right, officer, so you're concluding. All right, officer, you're concluding the same thing as Schrackle, Alice Mallory, and Victoria Williams when you say she was not in the crosswalk. When she was not in the crosswalk at the time she was hit, correct?
I've already answered that.
What was your answer, please?
That is correct.
Okay, thank you. And you concluded that Mr. Schrackle was not at fault for this accident. That's correct, because you didn't issue him any citations.
That is correct.
Thank you. And that Mrs. Potter was the cause of her own death. Correct. She stepped out in front of him. That's correct, based on the no citations issued. Correct.
I don't know if I determined she was the cause of her own death.
Well, if Mr. Schrackle had done anything to make her come off that sidewalk, when you have issued him a citation for not following the rules, you are an officer of law, correct?
I don't know.
You don't know. You've held this position for 7 years, and you still don't know the law that you are here to protect and defend?
You're the one that said I wasn't qualified. I didn't say I wasn't qualified.
You were not qualified for accident reconstruction, but I'm hoping, based on the 7 years experience, that you have gained that knowledge to issue the correct citations when need be, correct?
Which way do you want it? Am I qualified, or are you saying I'm not qualified?
You are not qualified for the accident reconstruction course, correct?
You're stating that I'm not qualified? Okay.
For the accident reconstruction course, that is correct.
Yes.
Okay, because you did not take any accident reconstruction courses that your department offered you, is that correct?
That is correct.
Thank you. However, based on your experience, not correlated with accident reconstruction, you can, based on your experience in 7 years of working, you can conclude that Mr. Potter was acting like a reasonable driver, and that's why you did not issue any citations, correct?
Objection, Your Honor. Speculation.
Overruled.
Officer, can I get an answer, please?
Yes.
Yes. Yes, you concluded that Mr. Potter was acting like a reasonable person, and that's why you did not issue him any citations, correct?
I don't know.
Your Honor. Objection. He's talking about Mr. Potter. He just stated Mr. Potter.
Excuse me. I meant Mr. Schrackle.
Okay. Well, the question was already answered, and if you want to re-clarify, Counselor, then please do.
Let me restate that you concluded that Mr. Schrackle was acting like a reasonable person, as any reasonable driver would have. That is why you did not issue him any citations the day of the accident, correct? Yes or no?
Yes.
Thank you. Now, officer, you took a deposition, is that correct?
I did.
Okay. Can you please turn I call your attention to exhibit number 39.
Okay.
Page 2. This is your deposition, correct?
It is.
Okay. On page 2, can you please read lines 15 through 17?
Objection, Your Honor. the defense hasn't laid down their foundation.
Sustained.
You already said that this is your deposition, correct?
That is correct.
And that the contents in this deposition, you were sworn under oath as you are here today, correct?
That's correct.
Your Honor, the defense offers exhibit number 39 into evidence, which I believe we already agreed upon.
According to my notes, Exhibit 39 has been agreed upon. There being no objection by the plaintiff, it's admitted.
Thank you, Your Honor. Now, Officer Young, can you please read lines 15 through 17 on page 2 of your deposition that you gave to your attorneys?
Yes. Based on my investigation, I concluded that no citations were justified. Based on that investigation and my experience, I concluded that Mrs. Potter was out of the crosswalk when she was hit. She was probably 15 to 20 feet south of the crosswalk at the point of impact.
Thank you. So, Officer Young, I will reiterate that you agree with Strackle, Alice Mallory, and Victoria Williams that she was not in the crosswalk at the time she was struck, correct?
Correct.
Thank you. Your Honor, the defense passes as witness.
Any cross?
Yes, Your Honor.
Okay, proceed.
Now, you stated that you didn't take a reconstruction course, correct?
That is correct.
And when you did your calculations for Mrs. Potter being outside the crosswalk, you did a calculations with formulas according to the where you saw the skid marks start, correct?
That is correct.
And the calculations that you made.
Objection, Your Honor. The plaintiffs have exhausted their time on cross of our witnesses.
Okay, objection sustained. Are you finished with this witness?
One last thing, Your Honor. Once again, officer, you concluded that Mr. Strackle was acting like a reasonable person would, and that's why you didn't issue him any citations, correct?
I've already answered that.
Move along, Counselor. Okay.
Your Honor, no further questions.
All right. This witness may step down. Call your next witness.
Your Honor, defense rests.
Defense is rested and the plaintiff has rested. Are there any motions? No. All right. Do you need a break? 5 minutes? 5 minutes for the plaintiff? Okay, a 5-minute break by the clock on the wall. Wait a minute. We're going to let the jury be excused first. Everybody rise. Okay, 5 minutes. Yes, ma'am. It's not admitted, I think it probably be more fair. Oh, if it's admitted, you can go ahead and put it up, but I don't know how much time you have, and you can remind the jury that they can take the exhibits back there with them, to deliberate, so you may not need to. You might remind them what it is, and tell them that they can ask for it, and they can. Yeah, because that could take up a lot of time. Yeah, you're right. Yeah, okay, but it's up to you. Okay, are the plaintiffs ready to proceed? Okay, is the defense ready for the jury to come in? Great, thank you. Okay, everybody, I want full decorum in here. I want you to have respect for the lawyers when they're speaking, okay? So a lot of work has gone into this trial, and each of you deserves it. Full attention and respect. You may be seated. Okay, is the plaintiff ready to give a closing argument?
Yes, Your Honor, and I'd like to reserve 3 minutes for rebuttal.
Okay. And before you do that, I guess I will read the charge. Yeah. Okay. Members of the jury, in the Circuit Court of Darrow County, NEDA Civil Division, in the matter of Jeffrey Administrator of the estate of Catherine Potter, Jeffrey T. Potter individually plaintiffs versus Charles T. Schrackle and the Schrackle Construction Company defendants. The jury is to answer the following interrogatories. The foreperson is to answer the interrogatories for the jury and sign the verdict. Interrogatory number 1, please state your findings of negligence in the following form. We find that the conduct of the defendant, Charles T. Schrackle, was blank % negligent. We find that the conduct of the deceased, Catherine Potter, was blank % negligent. Interrogatory number 2, please determine the amount of damages to the plaintiff, Jeffrey T. Potter, both individually and as administrator of Catherine Potter's estate. Amount, blank dollars. The percentage of negligence that you find to be apportioned to the defendant, Charles T. Schrackle, interrogatory number 1, is multiplied by the amount of damages you determine, interrogatory number 2, and that amount will be the verdict for the plaintiff, Jeffrey T. Potter. The members of the jury have unanimously answered the interrogatories in the manner that I have indicated, to be signed by the foreperson of the jury. Okay. At the conclusion of closing arguments, you will retire to deliberate. You will select among you a foreperson of the jury. After you finish deliberating, if you're able to answer the questions that are given you, then the foreperson will sign the verdict form, fill in the blanks, and sign it accordingly. All right, is the plaintiff ready to continue?
Yes, Your Honor, and I'd like to reserve 3 minutes for rebuttal.
3 minutes, okay. Do you want a warning?
I have a timekeeper.
Great, okay, go ahead.
May I
then.
proceed?
Yes, ma'am.
Thank you. Now, I know you've heard a lot of information, so I'm going to kind of break it down for you so you can have an understanding of what we have proven as opposed to what the defendant has proven. Now, you heard Mr. Potter testify about Catherine's last moments, how she suffered severe head trauma, and that it was a result of the defendant's negligence because he hit her. We did not hide anything from you. We were open and honest about his personal life. Yes, he developed a relationship with Cheryl Tobias, and it was almost 5 months after Kathy's death. And people grieve in different ways. That picture that the defendant was pointing out to you that he looked happy, well, it was a pose, right? When you take a picture, you pose and you smile. It was just to mask what was going on inside of him. I mean, would you rather see him depressed and suicidal or try to move on with his life? Mr. Potter was also truthful about everything, that it was a luxurious trip, that it was in the Caribbean, and that it was all just trying to mask the pain. He's no longer in a relationship with Miss Tobias because he can't move on to a long-term relationship because nobody could take the place of Catherine. Then you heard Catherine's boss. You heard Daniel Sloan, that he knew her for almost 11 years before she died, that she had a base salary of $85,000 plus benefits, medical, insurance, all of that, the year that she died. She was receiving bonuses because they valued her at Technosoft. And he was grooming her to become the next vice president. Then you heard our expert witness, Roberta Glenn, who has a doctorate in economics. And she's written articles in the Harvard Review and many more. She even named a few of the articles. She also wrote a book on loss evaluation in wrongful death cases. She's been a qualified expert witness in 24 different cases. And we move on. You saw how Marilyn Kelly, how she saw Catherine being hit, how she saw Catherine flying in the air, and how her head slammed into the pavement. She was right there, right where the incident happened. Schrackle, on the other hand, he didn't have good time management. He was running late. He was about to lose a very, very big job. He didn't apply his brakes. Catherine wasn't running. Catherine was just walking because she had the right of way. He ran a red light. That's why he hit her. He didn't see her. He wasn't looking in front of her. He didn't sound his horn. He didn't warn her because he was not being a careful driver. He was not looking in front of him. And then you hear their side. You hear Juanita Williams, who didn't even see what happened. She was already on the other side of the intersection. She's Victoria's mom. She's a 10-year-old. And I don't know about you, but I have a 9-year-old. And I know that every time I ask him to relate to me a story, the details are always different. We understand that a 10-year-old, she didn't even know, she wasn't good with measurements. She said it on the stand. She said that she didn't know. She calculated 200 feet, which was way beyond what Officer Young had calculated. Alice Mallory, who suffers from a condition, primary open angle glaucoma, she couldn't see exactly what happened. The defense is about to address you. Let them tell you why they were bringing up Potter's life after his death. Let them tell you why they're blaming Mrs. Potter for the defendant's obvious negligence and why their story just doesn't make sense.
Is defense counsel ready?
Yes, Your Honor.
Okay, proceed.
How are we doing? Everybody doing good? It's been a long day, I know. First of all, let me just point out, we are completely sorry that Mrs. Potter was in this accident. We're sorry for the loss that Mr. Potter's gone through. But this was Mrs. Potter's fault. There was no citation issued to my client, Charles Schrackle. The police officer had made a report, filled out what she felt was accurate depiction and what needed to be said and was stated by the law. Now, the plaintiff was dancing around the accident. The only witness they had to the accident was unhappy. Let me restate that. My client was not her favorite person in the world. She stated that she didn't like his demeanor, that he rushed and hurried through everything. But this isn't a true fact. They stated in their opening that they would make all these promises that they would prove that Charles Schrackle caused this accident, that it was his fault. This was not proved at all. A couple of different witnesses had stated that there was heavy traffic on both, as both sides agree. To be turning left at a busy intersection, if someone had started down the median or across the crosswalk, that there could have possibly been, for sure was one, possibly two cars in the line of vision of someone sitting at the intersection to the other side of the crosswalk. So to be able to tell me that she was or was not in the crosswalk, this is something that cannot happen. We have 4 different witnesses, one of them being a police officer, that state that Mrs. Potter for sure was out of the crosswalk. Now, to bring up the fact of heavy traffic, with her being out of the crosswalk and my client making a left-hand turn, there's no way with her being several feet, 15 to 20 as the officer states, there would be no way to see her through cars down a median at all. In several different depositions that we were stated today, that Mr. Charles Schrackle had stated that he had struck the victim on the front left corner of his truck. The only way that this could happen after you've passed the intersection is if you step off into traffic in front of a vehicle. We just want to remind you now as well that there was no way that my client, Charles Schrackle, caused this accident, had anything to do with her stepping off in front of his vehicle, and there was absolutely no way that he could stop it. What she had done for her decisions to walk in front of traffic, why this happened, none of us will ever know. We couldn't even begin to forecast. But that happened. We are sorry about the accident, but Charles Schrackle, it was not his fault that this happened. We find that there's no way that you could hold him negligent even to a small percentage to be contributory in any money that is owed. Thank you for your time today.
Your Honor, may I proceed?
Yes, ma'am.
Now let's just, I'm really, I really saw and appreciate how hard you stood still, but we're almost done. I just want to leave you with this last thought that those of us who have heard the testimony here have shared in this tragedy, and only we fully know what happened, how Mr. Potter is suffering through this. And so we just want to take back to what the defendant just addressed. Schrackle was not looking in front of him. He has no idea whether she was in the crosswalk or outside of the crosswalk. We do know that he was distracted because he could have been on his phone, but he wasn't sure. He doesn't even remember. That's what he stated on there. He was about to lose a big job, so he was on his way over there. Now about Officer Young, the only calculations that she concluded from her being out of the crosswalk was from that second page that was demonstrated, where her calculations were off, where she said she didn't take a reconstruction course. She wasn't qualified to give exact measurements as to how, because there was a formula. They didn't see how fast he was going or the size of the truck. They were inaccurate. But let me tell you, what is accurate today was that he was distracted and he caused her death. Now, as you go back to the jury room, you're going to take a form and you're going to look at the form, and we're confident that as you look at the form and it says, we find that the conduct of the defendant, Charles T. Schrackle, we're confident that you could put that he was 100% negligent. You will find that right underneath that is another question, and it says, we find the conduct of the deceased, Catherine Potter, and we're confident that you're going to write 0%. You know, if we find the defendant not responsible for this tragic death, are we not saying that he has the right to look at everywhere else except in front of him? She wasn't running. She didn't come out of nowhere. The fact is that he was not looking in front of him. Maybe next time he'll be looking at his smartphone. Maybe next time he's going to be texting. A moment of being distracted and careless can visit upon somebody else, of worry and pain and disability and maybe another death. The death of Catherine was so devastating to Mr. Potter that he's still tormented by the images of her last moment of his wife. That's why we're confident that you can award Mr. Potter $2.5 million. The money will not bring her back, but it sends a loud message to the defendant and his company to drive responsibly. And one last thing, today Mr. Schrackle will go home to his wife, who will have the emotional and mental support, while Jeffrey Potter is going to go home to an empty house. Thank you.
Ladies and gentlemen, you have heard the evidence and you are about to retire. Any exhibit that was actually admitted into evidence you are allowed to see if you so desire. You will ask the bailiff. The bailiff is the only person you will communicate with other than each other, and you will not communicate with each other about this trial unless you're in the deliberation room deliberating. So with that, I'm going to release you with the bailiff to retire for deliberation. Stand up. Okay, you may sit down. Great job. Okay, Amanda and Jennifer. Come here. Stand up in front of this jury or in front of the camera. attorneys present, all our parties? Okay, and there is a note. Is this a verdict or a note? A note. Okay, we have a note. And are our reporters ready? Okay, we have a note. It reads, we need a charge sheet and all admitted exhibits. Was Victoria Wilkins ever declared competent? Okay, so I am going to write, well, we'll send a charge, okay? Please find
Well, the reports are in, so we can see.
Yes, I know. I forgot to send it. I figured when I first got them. There, yeah. Okay. All right. We're on the record. So my answer is to please find the charge with the bailiff. The second one is you must specify which exhibits you would like. And the third one is please rely on the testimony you heard regarding any question. Okay. Okay. We're in recess, but please stand by. Well, I asked them to request them. We could, if you want to hurry it up. We can't. I didn't know if that would speed them up or slow them up. But it can only be the ones that are admitted. Okay, so that would be. Let me. Do you mind if I take them out of your book here? Oh, you have them out. Oh, great. But let's review. Okay, Exhibit 1, Exhibit 3, 5 and 6, 10. Okay, we're going to use. Okay, folks. We're going to. One of the exhibits is, we had that 10-10A thing. And we do not have 10 to provide because that was only in PowerPoint. And if there's no objection, I'm going to substitute 10A, which may cause a question with them because I'll probably remember that. But if that's okay with y'all, that's what I'm going to do.
Yes, Your Honor.
Is there a problem with that?
No.
Okay, 11, 12, 16. 18? Oh, 17, 18, sorry. 24?
We have it in color as we possess it.
My husband let me bring it.
Oh, good.
Because we changed while this reason.
Yes, okay.
They took the photo, which is to their detriment.
Yeah.
Okay, that was 32, 35, 36. Victoria Williams deposition. Right. 39.
Trying to sort out what exhibits that you would normally have all those.
Right, and I have this exhibit like this. It might be better. 39 is Michael Young, definitely. Correct. 42. Jeffrey Potter.
That was good. That was good. You had me scared.
43 and 44. So Dana Sloan and Roberta Glenn. I have one. They just need one, Dr. Benson. Actually, you're welcome. Another note. Okay. Do we have all the lawyers present? Okay, we're on the record. Please send Victoria Williams and Officer Young's affidavits. They're on the way. Right.
Is that in here?
Yes.
All
All right. Thank you. Yes. Okay, we're at recess now.
Okay. So, we also submitted it to which one? So, which one? Did we submit it? Yes.
Yes. Yeah. Which surprised me.
I should give them the giant. I'm sorry, it's gone way over.
No, it's perfectly fine. Got Evie covered. That was the only concern I had. And I just forgot. It's been crazy. It's been crazy lately between the, we just had all the superintendent scholars and it's spring, you know, so all the high schools especially, or, you know, they have all these events and ceremonies and Chamber of Commerce, and I've had the 2 candidate forums to do. I had one of them this week on Tuesday, so, you know, well, I haven't been sleeping that hot. I'm trying to do I'm just reading a record on a brief that's due,
you're sleeping.
May 7th. I know, it's hard to stay awake. And what else? Well, you know, and just the kids, it's competition season for Evie, so I was telling Susan she has 9 practices a week right now. Yeah, but it's fun, you know, it's all positive, so that's a good thing. Yeah, it's very happy work.
Well, I really appreciate you doing this. See how hard.
Oh, I know.
This group worked even harder than the last group.
They're so great. I hope I do a good job. I want to contribute and
You know, calling them up here.
Well, I know it takes longer, but
No, it's all right. No, and I told him, I said, you better get ready. You're not getting an exhibit admitted that you think you're going to get in, and then you call it for the bench.
I forgot to ask for objections on the charge, but I figured that was all settled already.
Like this, I didn't know where you parked, but that's the token to
Oh,
get out of
thank
the
you.
visitor's lot.
Okay, great, thank you. Yeah, I did park over there. The arm was up, so I didn't know if it was
I don't know if they just left it up because of the research conference.
Oh, okay. Okay.
Yeah, they work.
That looked interesting.
Got some future stars around.
Oh, definitely. And they're just so fortunate to have this opportunity. They're getting the best education in the world. And I was telling a couple of the ladies that they're just going to have a step up, you know, when they want to. This one, what's her name again? What I do with it? Anyway, she said she was planning on going to law school, and where are my names? Oh, what's this?
You wanted the name of
Oh
it?
yeah, there you go. It
talking about Christina,
was
or-
no, I know Christina. Heather, no, not Heather. Although I haven't even spoken to Heather yet. Amanda. Amanda was. We called each other out in the hall. Yeah, and she said she was going to. No. It was wait. It was Heather. It was Heather. That's right. She said she wanted to go to law school. Yeah.
Good time.
Yes. And I told her that it was great, you know, this kind of experience because, you know, you have a little better foundation. And it's great. I told at the South Texas shootout, I told them my advice to them was if you will prepare every case the way you prepared for this one, then you'll always be ahead. And
That's the advice you can give. Because I kept telling them it's preparation.
It is.
Preparation. I don't care who you're up against. If you're prepared,
You're right.
Something go wrong, but you're so prepared, you can recover.
And if you prepare that thoroughly, you're almost always better prepared than your opponent. It gives you confidence, and so when all the little twists and turns come about that always do, then you can kind of go with it. Because you're not,
You got enough of a fallback or whatever it may be. So
not so stuck to your script.
this Christina who's standing up over here.
Yeah, I know Christina. She's one of mine.
I think she's a natural. She's
Yeah.
very comfortable in this setting.
She is. Yes, she is.
And,
she was fun in class too. She was
Brian,
great with
AJ.
Victoria. That was when she was really shining with Victoria. It was hard not to smile.
Yeah, and I never told him about qualifying a child. Now I know.
No, but I did. That's why I made that comment because we had that conversation
you?
more than once.
Oh.
Yeah. Yes. Mm-hmm.
It's about, I was just wondering, how could I have presented the email that I was trying to get her?
Well, the problem was the objection was hearsay, and that was not a conversation with that was not something he said. That's something that he received from somebody else. But you got to the point anyway because of his response.
Yeah.
I thought.
Yeah, I mean, I described what was in the email, but I wanted the jury to see it. I didn't. I figured, because I thought that was one of the ways I could get it.
Well, you could have brought him in to testify. I mean, I know he wasn't on the list, but yeah, that's the way I would have done it. How would you have done it to get it in evidence? This is the, no, because it would not be something kept in the normal course of business. I wouldn't think, anyway. So the objection was hearsay because he wasn't here to testify to it. It was I never can get what's the defendant's name? The SCH Schrader? No, what's his?
Shackle.
I can't get that name, Shackle, for some reason. Shrackle. Yeah, it's that R, I think, that gets like crackle. But so it's not Shrackle. Shrackle was testifying, and she offered it, but the objection was hearsay, and so I sustained the objection. But then Jennifer offered the email from Shrackle in response to this, and I admitted that.
Yeah, there's case law if you, dealing with the exchange of emails on the admissibility out there. I'm trying to think of the rule on it.
Oops. Yeah, I've never had that come up.
I read somewhere, I think it was in the book, as a admission
Of a party opponent?
Yeah, that's what I argued.
But it's not his admission, though. It's not an admission of a party opponent.
But it had said somewhere I had read, maybe I was wrong, that the only way that you could not say business record was because he received it. It wasn't read by him.
Well, to be a business record, you have to qualify it as a business record, so it has to be kept in the regular course of business. Now, it could be, but there again, you would almost need the boss to come and testify to that, you know, or maybe the custodian of records could have come and testified that it was their practice in that company to keep any email that that documented how somebody was failing to perform. You know, a subcontractor was failing to perform, and in that sense, it may have been able to meet that test. No, not this business, because I wouldn't say that that's standard business practice. So, yeah, and besides all that, for a business record, you have to have the custodian of records for that business. Yeah, that's a problem. But Dr. Benson is saying that there's some case law about email, in particular to emails, that I'm not aware of. So maybe I need to find out about that.
I wasn't aware of the rule, and I put it in my stack of things I should remember.
Oh no, yeah, this is something I need to learn.
It was about the exchange of email when you respond. Somehow that
so kind of like optional completeness sort of thing?
It's almost similar. You know, it almost authenticates the one you receive because you're responding to something along those lines. Never heard of it before.
Yeah, I'm trying to think of how that would work, because I mean, it would. Of course, the best thing to do would be to have the boss there to testify, but there again, you were constrained.
He's the owner of the company, so he would be the boss, right?
No, I mean the fellow who wrote the email.
Oh, the guy.
Yeah, the contractor. Yeah. Mm-hmm. Yeah, he.
They didn't object to the other one. That's why I got it.
Yeah. But.
Good thing I went through the email.
I mean, because I'm trying to think, because I've had I mean, this was years ago though, so I'm sure it was before this case that you're talking about, because we weren't emailing back in those days. But it was something that about a memorandum or something that was said. I can't remember, and I was fortunate enough in those days to have an investigator work for me. So because I was in the DA's office, and I turned around to the investigator and I said, go to that, it was a school in somewhere in Brazoria County. I said, go to that school, find me that principal, bring him, you know. So in 40 minutes, I had the guy there to come and correct, you know, or clear up what was said. But you don't always get that luxury. You know? Sometimes you do, though. But I mean, I've had to do that before. I had a photograph it was a burglary of a habitation, but it was a rape case is what it really was, because it was a burglary with intent to commit another felony. And the state, I was defending this case, and they put a picture in the evidence to show this girl, because it was kind of an old case, and what she looked like at the time, just to show that, like Victoria with her teddy bear, that she was so young, right? And I was just hoping that she was born in Brazoria County, and I managed on a break to run down to and get her birth certificate or something, and to show that, you know, that the age didn't match the year on the picture. But it's in those moments of stress, like you know, and just like the demonstrative evidence, just like the visual aid. Okay, I can't get it in that way. What else can I do? I had a hammer once, and I was a misdemeanor prosecutor, but this was a dog case, and so they gave me this aggravated. It was an attempted murder, or was it a murder? Did he kill him? I can't remember if they killed him. That's awful. I don't even remember. Anyway, but it was a hammer that was used, and the hammer had little evidence, but we didn't. That was before DNA. And I couldn't get the hammer into evidence to save my life. I was going against Stan McGee, and I couldn't, because I had the book in front of me, and I wasn't that far out of law school, and I was like following it, and I could not figure out, it was in front of Judge J. Ray Gale, what I was doing wrong. I went through it like 3 times, and the judge just kept, sustaining the objection. And I tried to press, being fresh out of law school, I really tried to press the defense attorney to be specific in his objection. He just said, kept saying she hasn't laid the proper predicate, but you should be able to press them in what way? How haven't I laid the proper predicate? And the judge wasn't going with me. So we had a break, and I remembered, since I hadn't been there that long, I'd hung all of my pictures in the office with a hammer in the drawer of the coffee room that looked exactly like the weapon. And so I went upstairs, and I got that as demonstrative evidence and entered it that way. But yeah, I was just thinking, how am I gotta have a hammer,
That's quick thinking.
But, it's survival. It's how you get all the lines on your face and the gray hair, just trying to figure your way out of a hole or a noose or
I've found
whatever.
myself in too many holes over the years.
I know. It's what it is. Yeah, that's a cool thing. I know my first mock trial, and I think I told y'all this before, I had not had evidence, just like you guys, but y'all at least have had some, I had no training, and I was in law school, so, and that's how Dan and I met each other, but we had partners, there were 2, we had co-counsel, and so my partner had evidence, and he wrote down the basic objections on a page, and every time I had a witness and he wanted me to object, he'd step on my foot and point, and I was quick, so I'd stand up, hearsay, and I'm like, why is it hearsay, and what is hearsay, it's like,
That's funny. That is funny.
and I married my opponent, and,
Hey, no objection, obviously.
it worked. Well, sure. Thank you, honey. Yeah, these candidate forums are terrifying for me because you're sitting there and you have no idea, and the camera's on and you're like this, you have no idea what they're going to ask you next. No idea. And I'm thinking that, can I remember there are 44 campuses in CCISD? Because you just don't know.
I wouldn't want to be in that hot seat.
Yeah, it's
It's like a job interview.
oh yeah, definitely, and almost. Well, I guess the stakes are completely different because it's not financial at all, but it's the topic is just so broad. When you're talking about public education as the topic, and then the district specifically, you don't know. And the 2 forums we've had this time have been completely different. And they got pretty ugly. They asked some personal questions, too. I know. She got quiet all of a sudden. I thought maybe the bailiff was here.
Okay.
Well, did they have a verdict?
No, I don't think
Okay.
so. No.
Okay. Yeah, that's, it just got so quiet, I thought maybe we had a verdict. I wonder, do you think it would be appropriate to get a picture of me behind here so I can put on my candidate Facebook page? I've been trying to let them know what I've been doing. Just the cell phone's fine.
Sure.
Great. If you don't mind.
You want to get the whole group up here?
Well, would they let me put them on my candidate Facebook page, though? I'd like to, but I guess I could ask them. But since I'm affiliated in a way with the
You're an
university,
adjunct professor here.
but I don't have the waivers. Would that encompass? See? It's always something.
Are we right one here?
Well, I don't care. I just don't want to do something contrary to the university. If they tell me, that's good enough for me. But is it good enough for you? Is the thing. Or if they tell me they don't care if I put it up there, I don't know.
use the phone for educational issue of the system.
Is it in the spaghetti sauce? Okay. And they just.
They're about to come in? They probably don't know what office you're running from. Why don't you tell them?
No, what? Oh.
Yeah.
Oh.
Can I have your attention, please?
I'm embarrassed to say this, actually. I am a trustee. I'm a school board member for Clear Creek ISD, and there is an election going on, or will be. And I'm up anyway, and I have an opponent named Nick Long, and I'm finishing my 6th year. So I don't want to make a campaign speech, but I will just let you know that the election is happening. Voting day, election day is May 10th, and early voting is April 28th through May 6th. It is for District 2 only, which is around Freeman Library in Harris County. It's Nassau Bay. It's around McWhirter. It goes to 45, and then it swings down Egret Bay to Clear Creek High School and heads east through South Shore. So only people who live in District 2 can vote. But you can go online on the League City Chamber, and I have a Facebook page, and I've linked a forum. There's a candidates forum, so you can hear how we do. And Mr. Long has a Facebook page and a web page as well, so you can educate yourselves.
All right.
Good luck. Thanks.
You want to get right now, right in front of her?
Yeah. Pardon? Oh. Yeah. Yeah, so I've been posting on my Facebook page what I'm doing. I've just finished all the superintendent scholars, all the awards they've had this week. And so I'm going to take a picture and let them know that I was here tonight. So if anybody wishes to be in that, they can. But anyway, that's totally up to you. Do not be in the picture if you do not want to be on the Facebook page, and I have no problem with that. As a matter of fact, I'm not a Facebooker, actually. So.
I think I can speak for everyone here. We would all like to be in the picture with you.
That's all right, but don't feel. Yeah, please do, please do, please do. Yeah. Yeah, that's an example. If I said it is morning time right now, would that be the truth or would that be a lie? Okay, and so you give them examples like that that are very simple. Thank you. Very good. You did really great with her too.
I was like, I'm waiting.
Like, well, just simply you have to be careful with children. You have to remember that she's 10. But you have to remember.
I was running on like 2 minutes. I was thinking, I had a question lined up and I just had to pick the.
And the whole comic read up in the
I
beginning.
get it.
At the whole beginning, like after, I was like, don't be scared, it's okay. I was like, I was gonna play it. I'm sorry.
First time doing this, like.
But I just wanted to warn you because sometimes, like, the men lawyers will, sometimes when you have, like, oh, okay, well, or me, okay, when I was prosecuting that, you'd have this case, and this guy had good about himself, and the only person in the world who could speak for him was his mother. And normally, he didn't have that, you know, but sometimes you, and so the mother would come in, and as a, you know, they, you know, oh, he's my son, and I love him, and he used to be such a good boy, and he would mow the next door neighbor's grass, and, you know, all of nothing that had anything to do with the case. And I would never, almost, unless she just flat said something that was a lie that I could show, wouldn't even ask. I mean, I used to, when I first started out, I'd ask these, well, he's your son, and you love him, don't you? And you would just hate it, just break your heart if you went to the penitentiary, wouldn't it, you know? And eventually I just quit doing that. I just like, ask, no questions, just let it go. So you have to be so careful. That's just my opinion, but I think you have to be so careful in what you choose to ask when you have a very vulnerable witness. And the reason is the jury, and most of them are going to be parents, you know, they're just going to feel sorry for them, they're going to view things as unnecessary, and they're going to, look at you like, how could you, you know, be that way? So anybody who's a fragile witness, but it's very, it's a slippery slope, because, you know, because they can hurt you with their testimony. What you have to figure out is how badly are they hurting you? Is it worth going into it? And remember, if you ask a question, they can come back and ask another question that maybe they forgot to ask, you know. So yeah, it's just a judgment call. Thank you. Thank you for your advice. For what it's worth. Oh, that's great. Okay. Thank you. Okay, that is wonderful. So this is an authorization. It just says I authorize one whoever used my photo on her Facebook page in support of her campaign for re-election. I'm the worst politician ever. You're not. I just hate to ask for it. And I'm not, if you want to, I guarantee that it does not matter. If it were me, I probably wouldn't do it. So don't, if you don't want to be in the picture, it's perfectly fine with me. But if you do, then come up to the front, I guess. Yeah, here it is.
You know you're going to be in front, right?
Yeah, you
I love it.
You want to get like the fence on one side?
Yeah. I mean, when we take a trial,
Stop. You're not even a person.
Right.
This is gonna be interesting.
So we're all signing it.
that's how it's like, tall people,
Taller people do that.
Who's that for you?
Yeah, against the court.
In front of all these witnesses.
Oh, yeah.
I have sworn that I won't be in this picture. Oh no, I'm happy to be in the picture.
this picture doesn't matter.
Yeah,
When we take the photo,
Very nice.
stand up.
One big giant selfie.
Give her 20 back.
Who's gonna want this on? Here, I'll take it. Oh, no, I don't.
Dean, you don't want to do it.
Yeah, you know. It's a great experience.
You
That was my fault because I sent something nervous. I'm sure Dennis is that.
I mean, not exhibit 10, the other exhibits, but exhibit 10, yeah, okay. Somebody was not ignoring that.
The one they threw was exhibit 10, and then I called it exhibit 10, it was completely different. I was like, wait a second.
So what do you do? I've done that before too, you know, when the cat was out. And then sometimes I think, well, am I chicken? Because I got, or is it bad? Or am I going to look bad? And then am I going to call the jury attention to it? Or that I made a mistake? Or am I going to overemphasize
Your Honor.
the exhibit because now I'm objecting to it, you know? So it's a judge's call.
On the right, so it's just called actually correct. I was prepared to like go.
Well, that's, yeah, in the 80s, we call that a cool.
Yeah, that's why.
Thank you for being
I hope y'all realize how fortunate y'all are to have him and to have this program and this opportunity. This is not usual.
You put a letter on the witness list, and that's how you get.
That's something. Thank you so much. Thank you.
Well, and as many pins as he's gone through, it's just, they have a lot of hurt. I was like,
Yeah, you have to watch that as a lawyer. I always warn everybody else. And I know that, like, sometimes I'll come back 2 weeks later and say, yeah, but you're just going to have
Yeah, right. I literally picked it up.
I'm a lucky one. Thanks for inviting me to this meeting.
like now, we've already gotten our first day of trial. We're not gonna be as nervous the next time. Yeah, exactly.
I got stopped with the South Texas College of Law shootout, and they had law schools from.
I was a jury, and I got struck.
And what I told them was, if you will just be always in trial, if you will be as prepared as you were tonight. I mean, there's not a better secret in the world, really. And you're very prepared. Yeah, but if you will just always do that. I know you don't have a whole semester to go to class. And don't be afraid of bouncing off your peers. Lawyers do that, just like doctors do. You bounce things off each other and learn from each other, and somebody might have an angle.
Everybody back. Verdict's on.
I'm nervous.
Sir.
Okay. Let me get everybody together. Okay, ladies and gentlemen, we are on the record. I have just received a notice from the bailiff that a verdict has been reached. Is everybody present for the plaintiff? Okay, everybody for the defense? And you're ready to receive the verdict. Bailiff, would you bring in the jury, please? I'm going to ask you if either side would like the jury polled, and that means, would you like for me to ask each juror individually if this verdict is their verdict? So be prepared for that question, okay?
All rise.
Okay, be seated, please. Do we have a foreman? Okay, were you able to reach a verdict?
Yes, right.
And was that verdict unanimous?
Yes, right.
All right, I have the verdict and I'm going to read it. In the Circuit Court, Darrow County, NEDA Civil Division, in the matter of Jeffrey T. Potter, the administrator of the estate, and of Catherine Potter, Jeffrey T. Potter individually, plaintiffs versus Charles T. Schrackle and the Schrackle Construction Company, defendants. The jury is to answer the following interrogatories. The foreperson is to answer the interrogatories for the jury and sign the verdict. Interrogatory number 1, please state your findings of negligence in the following form. We find that the conduct of the defendant, Charles T. Schrackle, was 50% negligent. We find that the conduct of the deceased, Catherine Potter, was 50% negligent. Interrogatory number 2, please determine the amount of damages to the plaintiff, Jeffrey T. Potter, both individually and as administrator of Catherine Potter's estate. Amount, $0. The percentage of negligence that you find to be apportioned to the defendant, Charles T. Schrackle, interrogatory number 1, is multiplied by the amount of damages you determine, interrogatory number 2, and that amount will be the verdict for the plaintiff, Jeffrey T. Potter. The members of the jury have unanimously answered the interrogatories in a manner that I have indicated. Signed, Kenneth Kettler, the foreperson of the jury. Does the plaintiff wish the jury polled?
Yes.
Okay. Members of the jury, I'm going to ask you if your verdict was reached, is your own, okay? Juror number 1, I'm going to start with the foreman of the jury, Mr. Kettler. Is this your verdict? Okay. Juror, actually by your badges, juror number 5, is this your verdict? Okay, and I cannot see your badge. Juror number 2, is this your verdict? Mr. Lett, I cannot see your badge. Juror number 1, is this your verdict? Ladies and gentlemen of the jury, thank you very much for your service. You have helped resolve an issue that was not able to be resolved before, and you have served a very, very valuable function for your community and for this university. So please be proud of your service. You are now released from all of the instructions that you had before. If the lawyers wish to speak with you, they may ask to talk to you in the hallway or elsewhere. That is up to you. You may choose to speak with them or not speak with them. It is completely up to you. Thank you again for your service. You are released.
We'd like to thank the jury as a unanimous for being here for 4.5 hours. Great job. We love y'all. Thanks for the support back there.
Good question. Good question.
Good job, woman. Held it together.
Just letting you know we're going to be filing for appeals.
Cool. That is good.